1969 up to 2016.
Anyone there? Does the impugn notifications appears to be in terms of the provisions of the building of the Water Act? That being so, the aforesaid measures having been taken by the PCB for preventing and mitigating water pollution, which is crucial for sustainable development and public well-being, the same cannot by any stretch of the imagination be said to be arbitrary and unreasonable. In view of the foregoing, the petitioner has failed to make out any case whatsoever warranting interference from this court under Article 226 of the Constitution of India. Hence, writ petition fails, dismissed.
Mention. Lordship, in item number 29, I have filed an IA. The report has not been come. Made me call for
Item number 9,
29, Lordship.
call for.
Call for.
All right.
May I please, Your Worship? With due consent of others, I beg to mention item number 4. Password number for the day. 4.
Why?
Why you always say during pendency this case, the charge sheet has submitted. I have filed another petition. It's not record.
Then this becomes infectious if you have filed another petition.
And next week, you will
Why?
vote the petition. Let me also there because
As prayed for by Mr.
yes, Islam.
S. Islam, Learned Counsel for the petitioner, relist after 2 weeks on a date to be fixed by the bench.
Lordship, item 13, Lordship, 1-3, Lordship. Lordship,
1,
on instruction, Lordship, I would like to
Item-
1-3, Lordship.
1, 3.
30, yes.
You want to withdraw this bail application? Mr. Ajad Ahmed, Learned Counsel for the petitioner, also heard Mr. B. Sharma, Learned APP for the state respondent. Mr. Ahmed, Learned Counsel for the petitioner, submits that he has received instructions from the petitioner not to press the instant bail application and accordingly makes an endorsement to the same effect. In view of the aforesaid endorsement, the bail application stands dismissed on being withdrawn.
My pleasure, Lordship. I beg to mention item number 27, Lordship.
Yes, what do you want?
Lordship, kindly adjourn the matter for the day, Lordship. My senior is not well today.
Why this 27 is for orders?
Order.
Why is it for orders? You don't know. Why you did not? When matters are listed in the order column, basic courtesies of counsels, whoever is mentioning is to find out why it is for orders. Is it so difficult for you to check with the order sheet of the file and see why the matter has been placed for orders? Mr. Counsel? These are basic things which you are required to do. These are the assistance that the court wants from a counsel. Especially when they are listed for orders. They're not just listed for orders as a matter of course, they're listed because some orders are required to be done. There may be it may be that because the TCR has come, perhaps you wait. I shall accommodate you, but you wait. Or you file to did you have a look at item 27 by the time the other mentions are going on, you just have a look. Yes.
I beg to mention for item number 32, Lordship. The connecting appeal is heard by division bench, Lordship. And we filed in IA for
Connected?
connected appeal is heard by the division bench, Lordship. With
Yes.
20 years punishment, Lordship. Wrongly listed before.
Oh, acha. Item 32.
32, Lordship.
Mr. Hassan. You
On
Mr.
behalf,
Hassan?
our hope on behalf of N. Hassan, Amicus curiae.
Mr.
Our Hawk on behalf
R. Hawk, Learned Counsel, appearing on behalf of Mr. N. Hassan,
of N.
Learned Amicus Curiae submits that this criminal appeal has been wrongly listed before the single bench. Let registry verify and place it before the appropriate bench.
Another prayer for item number 10, Lordship.
Yeah.
Kindly adjourn the matter for the day, Lordship. We have various part-heard matter to the Lordship. Learned Arguing counsel is
10/8/25.
court
All
11
right, as prayed for by Mr.
R House.
So and so, learned counsel for the petitioner, relist after 2 weeks on a date to be fixed by the registry.
Obliged, Lordship.
May I please, your lordship, with the consent from the other side, I beg to mention item number 26.
Item number,
26.
what do you want in 26?
Your lordship, as the conducting counsel is, won't be able to attend the court today due to some personal difficulties, so matter may be adjourned for the day.
This is an order matter.
Yes, your lordship.
You wait. Let us see why they have come for orders. Order matters, please don't make mention.
Your lordship, service has been completed.
So let us see if service is completed, we'll pass an appropriate order. You please wait.
Bless you.
Don't make mention of order matters. Because of your mention unnecessarily, it will again come in the order column. We'll see. There will be no orders prejudicial to you that will be passed. Be in court. Yes,
Your lordship, LCR has been received, lordship, and matter is ready for hearing.
then you see, you would have made a mention and left. Again, the registry had to release this matter
Again on the same, same orders column.
in item 20.
7, lordship.
In item 27. Anyway, you wait for your turn.
Okay.
We will see because that order, I have to open the file. You
All
wait
right.
for your turn. Don't leave.
For admission, item number 1.
Some instructions were called for.
Yes, Lordship, the petitioner has told me that he is able to pay rupees 9 lakhs in 3 installment within 3 months.
He's able to pay,
Rupees 9 lakhs,
not 11 lakhs.
not 11 lakhs 60, because it was earlier settled and he was 2-3 occasion.
Your
Sorry?
settlement offer already failed, my lord.
You know, 2-3 occasion he went for pay by making payment of
What
8
is
lakhs.
the relief sought here?
So relief sought for here, Lordship, petitioner may be directed to pay with 8,50,000 respondent bank since denied to receive. So, this is the only prayer actually. Remaining part of settlement amount may be allowed to deposit by the
They
petitioner.
Pay the amount within the stipulated time. My-
1 second, ma'am. So earlier the settlement amount was 8,50,000.
8,50,000.
8,50,000 is pending.
That was pending.
Yes,
Now it has become 11,60,000,
yes, including interest.
including interest.
8,50,000, the amount has already, they have failed to pay within the stipulated time.
That is why the interest.
Yes, yes, my
I am dismissing it.
yes.
You will not make payment. That can't be. This court is not here to act like a mediator for these matters. They are ready to settle the matter. They settle the matter till you did not pay. Now again you
The
are
petitioner
negotiating.
went for several
And
occasions.
my lord, this matter is pending from 2020.
I'm dismissing it.
Several occasions he went for making payment.
That is all right.
I filed additional affidavit also. That is the case. The petitioner went for making the payment. They have denied to receive it.
Where's those statements?
Yes, I make my case is this.
Where is that statement? That you have gone to make payment and they have not received?
No, my lord.
Lordship.
You don't know where that statement is.
6, paragraph number 6,
Paragraph 6 of
page 6 of the
your petition.
petition. In middle.
Where is your reply to paragraph 6?
Uh, page number 15,
1.5.
115. I know. Point
Yes.
7.
Yes, read. Disputed.
It's
How can this court go into all these disputed questions?
and as per the
Please
annexure A is
enlighten
number
this court, how this court in Article 226 enter into these disputed question of facts. This is not a civil forum.
Yes, of course.
Then
But can you make me further instruction?
no
Give it in-
further instructions. Your instructions are clear. Your client doesn't want to pay 11
That-
lakhs. He doesn't want to pay the
they are
interest.
taking the advantage of interim order.
That cannot go on like this. And this is not a court. This court is not sitting here to get into all these negotiations. When you owe the money, it was your duty to pay. They had given a settlement offer. It was your duty to honor the settlement and make the payments on time. Now, failure of that, when they are issuing notice, you have come, obtained a stay. Despite that, they are again giving you some, they are ready to settle, but that also you are not ready to accept.
I'm accept it, but
No,
I'm not in a position now to get this way. So one date maybe still, I stuck my.
Monday. Monday, you come with your instruction, otherwise, ma'am, you also take one instruction. If they are ready to pay this 11,60,000 in 1 or 2 installment,
Yes, yes,
whether you will be accepting that or not.
yes, yes,
Keep that instruction also ready,
yes,
because then I can dispose it off. All right,
yes.
I'm making it clear.
Yes,
Heard Mr. B. Fukan,
people.
learned counsel appearing for the petitioner, also heard MS M. Day,
MD.
learned counsel appearing for the respondent bank. Mr. Fukan, learned counsel, upon instruction, submits that the petitioner is willing to pay rupees 9 lakhs as full settlement order instead of the rupees 11,60,000, which is inclusive of interest as demanded by the respondent bank. It appears that the petitioner has, it appears that earlier the entire dues of the petitioner was settled by the bank at rupees
63 lakh.
8,50,000.
No, it
Huh?
it was settled at 63 lakhs 50,000.
Settled at
56 lakh.
66 lakhs,
56 lakhs.
66 lakhs,
Hmm.
out of which
63 lakhs 50,000
8,50,000 was due.
due.
8,50,000 was failed, out of which the petitioner failed to pay 8,50,000, for which notice was issued by the bank,
As
At
per-
which
as per
stage?
the annexure A.
the writ petition was filed.
The notice was
appears
issued by the
that-
bank.
It appears that it appears that this writ petition is not maintainable inasmuch as disputed question of facts have arisen. However, Mr. So-and-so seeks a short accommodation to obtain instruction once again from the petitioner if the petitioner is ready and willing to pay the final settlement amount of rupees 11,60,000 to the respondent bank. Stop. Prayer is allowed. Relist on Monday.
My lord, can be fixed on Tuesday.
All right, Tuesday.
Obliged.
Item number 2.
But I'm making it clear, no further adjournments would be given.
Lordship,
Tuesday.
bank was not issued any notice,
Sorry,
and bank was not issued any further notice
further notice
When-
of what?
for demanding 8,50,000.
No, but you have said in your prayer,
Whenever I am going to pay, they refuse to accept.
that is what they are disputing.
Obliged.
That is what they are disputing in the environment.
Okay.
Yes,
My lord, Lordships, in item number 23, Lordships, I filed dusty affidavit, my lord. Can it be called, Lordship?
item, you want it to be called
Yes, Lordship,
All right.
23, man. Obliged.
406, 420.
The CD was
here-
called for.
And last occasion, CD was called for, my lord. Lordship was pleased to call for CD, my lord. Here I have received that one information that, my lord, in this case, FR submitted. Final report,
So is it closed?
my lord.
Closed.
Close.
Then
Since FR has been submitted, this may be closed in view of the submission.
heard Mr. A. Ganguly, learned counsel for the petitioner. Stop. Also heard Mr. B. Sharma, learned APP for the state respondent.
এখন দিয়ে দিব।
This application is filed under section 482 of CRPC for quashing of the FIR dated 15/12/2022 lodged with Misamari Police Station, on the basis of which a case was registered as Misamari Police Station case number 76 of 2022, corresponding to GR case number 1828 of 2022, registered under sections 420, 406, 294, 506 of IPC. Mr. Sharma, learned APP for the state respondent, submits that he has received instructions from the Superintendent of Police Sunitpur Tejpur white letter dated 15/5/2025 that
It was received from OC concern and superintendent.
that the officer in charge of the Misamari Police Station, Sunitpur, Assam, by by communication dated 11/5/2025, has submitted that FR by Misamari PS FR number 03 of 2023 dated 31/3/2023 has been submitted by the IO ASI by the jurisdictional IO and has been by the IO to the magistrate, to the jurisdictional magistrate court. Stop. A copy of the said communications are kept on record and marked as X.
Right.
It appears that since final report has already been submitted, nothing, that final report means it's closed, isn't it?
Right.
The final report has been submitted. Nothing survives in this criminal petition at this stage. Accordingly, the criminal petition stands closed
Right.
as being infractious.
Right.
Lovely. Item number 3.
Disposed of.
Actually, so Lordship, by the last order, respondent number 3 and 4 was impleted.
3, 4 and 5, Lord.
And my lord, we have not received any instructions yet. My lord, you may give us 3 weeks time
You have not received any instructions for what?
from the department. My lord.
Lordship, on the last date, if I may humbly submit, Mr. S.K. Talukdar has already produced all the instructions before this honorable court. And the instructions which have been received by Mr. S.K. Talukdar on the last date are the same as the affidavit which has been filed by the bank. So all the materials which were produced on the last date are the same as what the bank has filed by way of affidavit.
Lord,
You want what information?
my lord, in the last order also it's not in
9/5/25.
yes 9/5/25. So 3, 4, and 5 is implemented. Therefore, no instruction has been received in the department. So we may take 3 weeks time and then we may file affidavit.
You want to file affidavit on behalf of 3, 4, and
3,
5.
4, yes, my lord. 3, 4.
right, let them file because they've been
Lordship,
newly
2 weeks,
impleaded.
2 weeks may be granted.
Mr. Your name?
K. Sodial on behalf of SK Talukdar.
Mr. K.
K. A. Sodial,
K.A.
aka
Sodia.
Sodial,
Sodial.
Sodial.
Learned counsel appearing for the
On behalf of SK Talukdar.
appearing on behalf of Mr.
SK Talukdar.
S.K. Talukdar, Learned Standing Counsel Corporation Department, seeks 3 weeks time to file counter affidavit on behalf of respondent numbers 3, 4, and 5. Prayer is allowed, relist after 3 weeks on a date to be fixed by the writ.
Lordship, I humbly pray if a date may be fixed because
Will
this
come.
matter, Lordship, for the past 10 years, 55
years.
lakhs.
2 years, but sorry, 2 weeks, but. File it
55
within
lakh
2
rupees
weeks,
is
huh?
lying with the bank, Lordship.
All right, next.
Item number 5. This petition, writ petition relating to my lord compensation as my lord they are evicted my lord without notice my lord.
Without.
There is a order, your lordship go to it by order dated 7/5/2025 my lord. Second paragraph my lord. Your lordship
7?
got, 7/3/2025.
Yes.
Second, Mr. Borua submit there on instruction the credentials of the petitioner number 2 to
Have been
5
verified.
have been verified with regard to APDSL consumer numbers and GMC holding numbers. Borua has submitted that as the verification process is complete, the matter will now be placed
Where,
before
who's
the
appearing for the district commissioner?
district.
Yes.
Now, thereafter, my lord, next order, my lord, 9/5/2025, my lord. Mr. Nayak submit that, my lord, your lordship got it, my lord. And senior government advocate appearing for the state respondent submits that verification process underway by ascertaining as to whether the petitioners were occupation of the land from which they alleged to have been evicted.
The verification is done.
Done, my lord. And
Well-
one is received, my lord. I am on not on one. One already got, my lord.
Huh?
Petition number 1 already received the compensation, and 2 to 5 they are not till today, my
No,
lord.
but here it says the credentials of petition number 225 have been verified.
Yes, ma'am.
Then, and he says, Mr. Borwa had submitted that verification process is complete.
My lord.
What more to be done then, district commissioner? Why is it not being dispersed? Why again, from the state respondent, this submission has come that the verification process underway for ascertaining as to whether the petitioners were in occupation. But their verification has already been done as
Done.
per the submissions of Mr. Barwa.
Lordship, Miss Burra, I was appearing.
Sorry.
Lordship, we have placed, we have verified the individuals and we have placed their names before the district commissioner, Lordship.
Correct.
They have
So
to-
now, then, on the last occasion, again, Mr. P. Nayak had. You are appearing for whom?
Lordship, on behalf of Mr. P. Nair.
So, you say one thing, Mr. P. Nayak says another thing. You say verification is complete. You said the same on 7. Today also you are saying the same. That Mr. P. Nayak on the last occasion again said verification is on, is in the process.
Now we have verified, we have placed it before.
You
the
see, you
DC.
please give me the correct information. Because this court cannot be going on recording your assurances and then on the next day again a contrary submission is made. That can't go on.
It is placed before the district commissioner from district commissioner, but I have not received any for some time actually. After 3
That will give you, but provided it has gone to you. Because both from the last to last order, it appears it is now you who has to do something. How much is the compensation, Mr. Bora?
5 lakhs. It's
And since when you have not got it?
my lord, only petition number 1 received and others are not.
They have been evicted.
Evicted, my lord, without.
When?
Evicted on my lord, 13/5/2022.
22.
My lord.
13/5/22.
22, my lord.
Why then the matter also filed in 23? Now we are in 25.
My lord.
If the district commissioner doesn't give the information by next week, then he has to be in the court.
My lord.
No, it can't go on like this. Once the instructions comes, verification complete, then the same, on behalf of the same respondent, again an information comes, the verification process underway, which is at an advanced stage. Once the process of verification is concluded, decision for grant of compensation to the petitioners would be arrived. Isn't it?
My learned friend, I have seen my lord already verification completed. That was submitted my lord DC my lord for this. This may be recorded my lord.
No,
This order my lord.
which order? But have I understood this correctly or not, Mr. Bora? Because 7.3 and 5.4
Contradictory.
are contradictory.
Contradictory.
Date, I submitted that it will be placed and now it has been placed before the DC lordship. And the second,
Now be placed.
we have placed it before the DC lordship.
Then, Mr. Roy, you have to give me a time frame. You give me a time frame by next week. By which, by what, how many months? Reasonable months. 2 months. You make the payment.
Well, dispose of the matter on the basis of that matter.
Lordship, let me have the instruction.
Let him have that instruction
Fine.
because otherwise we can. Actually, if this has come
Yes, ma'am.
with reference to the subject cited above, I am directed to inform you that the verification of the evictees have been submitted. The names of the verified individuals have already been forwarded for further processing and inclusion in the official list for compensation. The disbursement of compensation will follow the standard administrative procedure, and the time required for release will depend on the required procedural formalities by the district commissioner.
That's why, Lordship. Let me.
I can dispose it.
My lord,
Lordship, let me have the instruction after 2 weeks, Lordship.
2 weeks.
Lordship.
I'm taking it at the as the last item today. You obtain the instruction within what time? At the end, you call this. Mr. Bora, you wait.
man,
Give a call and find out.
much. Item 6. Can it taken at 2 my lord?
At 2.
My lord.
Mr. Roy at 2. Ms. Borwa at 2.
Much.
My pleasure. Now, I am selling the entire criminal proceeding matter pending against me, my lord. I am challenging my entire criminal proceeding matter pending against me, my lord, before the matter learned.
Charge sheet and the order of framing charge. Yes,
Under section 379 IPC, my lord.
Mr. Sharma.
My lord, here,
The LCM and the case diary was not
received,
received,
my
my
lord.
lord. Because the ones.
Counsels, please refrain saying the word L.
My lord, trial court.
PCR.
My lord, trial. Only CD part. CD part.
TCR is required.
CD part is required. Other orders part are here, my lord. But
So you have with the CD then.
no, my lord.
it has
First
paid-
case, my lord.
Oh.
Just pay the
Uh,
court of court.
It appears that the earlier it was called.
Call, my lord. It was called.
Only the search and the orders were.
It appears that the scanned copy of the trial court called by this court earlier by order dated 17/5/2024 is yet to be received. Let the same be called forthwith. Assent.
My lord, report one part is received, my lord. Charge sheet part is received, but case there 161 statement that are not available.
then you-
But you may call for only CD part.
I mean,
Then
the
you
CDR
take-
kept in a ZR bank, that's why it is not.
It is submitted at the bar
Hmm.
that the scanned copy of the trial court records received does not contain the
Charge, case there.
case, does not contain the photocopies of the case diary, which is essential
Right.
for effective adjudication of the criminal petition. Let the scanned copy of the case diary be called for from the trial court through the registry of this court.
My lord,
forthwith.
my lord,
Relist on such and such date.
my lord.
But there is an interim of that payment control.
Date ki dila?
16.
16 June.
Sir.
Interim, if any, shall continue till the next date of lesson.
Item 7.
Yes, Mr. Kotoki,
Yes, we have come against the order of framing charge, my lord.
order of framing charge.
Yes.
Before starting my senior friend, I have engaged the legal aid counsel, my lord.
Hmm.
The petition which was supplied, my lord, that
Huh?
petition, my lord, which was supplied by the legal aid, my lord, that some pages, my lord.
You could have told Mr.
Record, my-
Kotoki,
15, my
Mr.
lord, then I.
Kotoki would have given you immediately. You don't have to come with all that before this court.
My lord.
Actually,
Development in this matter. I'm appearing on behalf of respondent number 2, who is the informant of the present case. My lord, there is some recent developments, my lord, that I file an affidavit also, my lord, that the everyone pursue the matter in the court.
That affidavit is here.
My lord.
What was the case?
yes, my lord, actually what happened, this petitioner was the deputy general manager, my lord.
376, very strong. Where is your affidavit?
376 not made out, my lord. At best, it can be a case of,
Anyway, you supply a copy to the legal aid.
yeah, I come submit.
And Mr. Your name?
Yes, I can.
Mr. P. Cycle, Leonard Legal Aid Council submits that a copy of the criminal
Petition as well as
petition
the affidavit, I will supply the affidavit.
and the other connected papers are yet to be received by him.
None.
Let Leonard Council appearing for the petitioner furnish the copies of the petition as well as all the affidavits to Mr. So-and-so, Leonard Legal Aid Council. Relist next week.
Next week.
Relist after a week on a date to be picked by the registry.
Because at best, it can be a case of 354, that's what I'm.
All right, we'll see on that day.
This matter, my lord, the trial proceeding is going on, and I have received, my lord, summons to the witness. So I have to appear in the court.
You appear. You had filed. You are the informant.
So,
You are the informant. You have
directly he wants
case. Now you are in a hurry to withdraw it.
My lord,
That can't be. The 354 allegations are 376 is also there.
my-
Anyway, next. Please call the next matter.
May it please your lordship.
Yes.
Your lordship, this respondent, the private respondent, your lordship, has constructed a notarized link-
Counter affidavit has been
has
filed.
been
or
filed,
not?
your lordship, has been filed.
Huh?
Has been
Bora?
My lord, we have not filed, but the authority was directed to file.
GMDA.
Yes, my lord.
filed an affidavit, your lordship.
You have filed.
It was filed on 23.
And my lord, we have not been served with a copy, my lord.
Why copies are not being served? Why should these complaints come before the bench? Council should give a copy if you are filing something to each other. But your affidavit otherwise is also not before this court. Mr. Deori, have you received the
Yes,
affidavit?
yes, your lordship, I have received it on 28/4.
You say it like this. Heard Mr. T. Deori, learned counsel for the petitioner. Also heard Mr. D.P. Bora, learned
I am for respondent number 4, my lord.
any counsel,
No, my lord.
learned counsel appearing for respondent number 4 and MS A. Bora. Bora Thakur. Learned counsel appearing for
1, 2, and 3.
1, 2, and 3.
14
Within bracket GMDA. Stop. MS MS Bora Thakur submit that an affidavit in opposition on behalf of the GMDA respondents have been filed on 28/5/2024. 2024 or 2025. However, the same is not on record. Let registry verify and place the said affidavit in opposition on record. Mr. Bora seeks how much time?
2 weeks time, my lord.
Takes 2 weeks time to file his reply in the matter. To file return in the matter. List after 2 weeks on a date to be fixed by the registry. It is needless to be clarified that copies of affidavits be served on the remaining respondents as and when is being filed.
Very grateful, your lordship.
May I please, Lordship? Lordship, kindly pass out this matter for the time being, Lordship.
Lordship, I have received the report, sir.
All right, time being. Yes.
My lord, here criminal appeal jail, my lord.
Oh, so
Lordship may appoint some amicus curiae, my lord. Here.
has to be also admitted
Not my lord, perhaps from today, my lord. First time, my lord.
first time.
Named, not appointed amicus curiae.
Mr. Bora? There. No.
Baro. 11.
This is an appeal. This jail appeal is directed against the judgment and order dated 5/3/2025, passed in special POCSO case number 120 of 2025.
For a fixed date, lordship, they
After 1 week.
oblige, lordship.
Matlab, regarding land compensation for the land and Zirat, Matlab.
Yes, on the last occasion, you
Yes.
had brought a wrong brief.
Yes, Matlab.
This time you are carrying the right brief.
Yes, Matlab. Yes, Matlab.
But this time your counterpart is missing.
Yes, Matlab. But Matlab, we have Matlab filed the Matlab affidavit also, Matlab.
Today,
No, Matlab. Long back, Matlab. It is probably in the file, Matlab. In the file, Matlab, probably it is there.
yes, affidavit in opposition of R4.
Yes, Matlab.
R3 is also there. You are R3. Mr. Goswami? Where is petitioner? He's not here. None appears for the petitioner on call. Heard Mr. G. Goswami, Learned Standing Counsel, appearing for the NF Railway, and Mr. N. Goswami, Learned Counsel, appearing for respondent number 3. If he was there, I could have anyway relist after 2 weeks on a date to be fixed by the registry.
Deeply.
Yes, Mr. Das?
Kindly take item number 42 and
42.
please see page 35 of the rate petition
Page 35.
of item number 42.
Yes, it's an AO.
No, see on the right hand side of the top, my lord, I think you're. I thought, yesterday my learned friend was briefing me because normally we see affidavits. I thought that I should point out. I think my learned friend is now looking very busy with this.
I had appeared earlier.
Appear for the
The list before any other bench without me, huh?
interim order is being already there.
How can I do
That's
that?
how.
Anyway, it will come immediately. Itu Rupak Kali kan Monday kan korai diok. Koi dipo benchot moi lobo no. Okay. Also obliged.
May I plead the lordship, my lord? This is an application under 483 of BNS, my lord. The petitioner has been arrested on 19/12/2024. The FIR is at page 13, my lord. FIR at page 13, my lord. There were 2 accused, my lord.
FIR is at page 13.
13.
1 second.
2 accused, my lord. And in respect of the 1 accused, my lord, your lordship has been pleased to grant bail, my lord, for violation of the provisions of Article.
22.
Yes, my lord.
One.
22. Yes, my lord.
FIR is 13, you said, right?
Yes, my lord.
You are which one? Accused number?
Accused number 2, my lord.
Faizul.
Fadidul.
You are Faizul.
Yes, my lord.
And earlier granted for 1.
1.
What
Accused
is it?
number 1, my lord.
Papidas.
Papudas, my lord.
Who does?
Page 16, my lord.
Page?
Page 16, my lord.
Yes.
The name of the accused,
Yes.
my lord.
Now, where is your, according to you, grounds of arrest not?
Not, it was not informed.
Where is the arrest memo? Where are the notice? 47 notice.
Petition for ground petition ground
Mr. Locker, notice doesn't, arrest memo is there. Search and seizure list.
11.
Okay.
Where is the arrest memo?
It is the arrest. Take mark. I can take mark.
Hmm?
I can take mark it. The
And my lord, in the earlier order, at page 28, my lord, para 17, my page 28, para 17, the finding of the court is there, my lord.
Page?
Page 28, my lord, the order starts at page 20, my lord. But relevant portion regarding the finding of this honorable court.
No, but that has to also fit in your case. That's why I need to see.
Yes, my lord, the same CD, my lord.
Same CD.
Same CD, same arrest, same.
You see, same CD, I understand. But I have to also, because the notice can be different to you. That I just want to see, because 47 is an individual notice, right?
Yes, my lord. Yes,
The one which is at page 23 is issued to Papudas.
yes, my lord.
Similarly, the arrest memo at page 24 is to Papudas.
Yes.
Now,
my lord.
before I grant you the bail, Mr. Borat,
in-
you think that this
Yes,
court
my
has
lord,
to
your
see
lord.
those? That
Yes,
is
my-
what I want to see.
Yes, my lord.
That is
Yes,
why
my-
Mr. Locker is trying to point it out from the, because you
Yes,
have
sir.
not annexed it.
Yes, my lord.
Have you annexed?
I know, I
Correct.
didn't.
So let me have a look at
Yes,
it.
sir. Just I am pointing out the points.
I am aware.
Yes, my lord.
Yes. Indicate order. Should I start dictating? You
Yes.
pointed out,
Yes.
because
The
at
same-
least the 47 indicates it is not there.
It's same.
But did you get the arrest memo?
That's that's right, man. Pink color flaglets. Pink color flaglets. That
We are now concerned with Faisal.
Fazil.
Fadidul.
You take down, huh? Heard Mr. D.P. Bora, Learned Counsel, appearing for the Petitioner also heard Mr.
Yes.
P.H. Lockor, learned APP for the state respondent. This is an application filed under section 483 of BNSS 2023 seeking regular bail to the petitioner, i.e. Faizul Khan, who was arrested on 19/12/2024 in connection with Kanpur PS case number 161 of 2024, registered under section 61(2)(123 of the BNSS, read with section 20C 29 of the NDPS Act 1985, read with section 4(5) of the Assam Bhang and Ganja Prohibition Act. Now, try this pink flag. Put an A for you. This order is already there. So para 3 as it is. Para 4, only the name of the council changes. Okay, I have underlined. Para 5, name of the council changes. 6, same. 7, same. 8, same. 9. In 9, where in the quoted portion, you say pink star A. This is here. Okay, I have the star and I put A. Okay. Para 10, same. 11, the quoted portion will be B star from this record. Okay. Para 12 remains same. Sorry, para 12 only till mention. Arrest memo is also here. Where?
That pink color flag also.
Pink color.
One of the pink.
There is no more pink.
One more is yellow, sir.
Huh?
One more is yellow, sir.
This pink is different.
Sorry.
You did a star and mark C. Para 12 also same. In that in the quoted portion, star C. 13 same. 14 same. I think rest everything will remain same.
Yes, my lord.
15 same. 16 same. 17 same.
Same, my lord.
18 also same. Yes, everything else remains the
Yes,
same.
my lord, it will remain same, my lord.
In B, I am held deposit is from outstation, this person.
No, my lord. Local person from that place, my lord.
Passport visa, I'm removing it and I'll say Aadhaar card.
Yes.
Normally, it is given nursing. It is perceived because so that they cannot move any other
Alright.
place.
I don't think he has got passport, my lord.
If any.
Yes, my lord, yes.
If any.
Yes.
You have it, you give it. If you don't have it, don't.
This is the arrest people also already marked it.
Arrest I have inspection.
Inspection. Inspection number is also yellow. sir. Right.
Disposed of, 14. This order you will get it here. Just mark, put a star and put C in your pink flag. This is your Marshwag detail. All right.
Deeply applied, my lord.
Good luck.
The numbers.
It has come for dismissal, still no one there.
Such.
Right now. This matter was listed today. On no, before you say none appears for the petitioner. Heard Mr. N. Goswami, learned government counsel, appearing for the state respondent. This matter has been listed today with the remark for dismissal in the cause list. It appears that on the last occasion, I-26/5/2025, despite the matter being called twice, there was no representation on behalf of the petitioner, and accordingly, the matter was listed today with the aforesaid remark. However, despite the matter being listed today with the aforesaid remark within quotes for dismissal, there is no representation on behalf of the petitioner. That being so, and also say that the appropriate that 4 names of the learned counsels appearing on behalf of the petitioner is also reflected in the cause list. That being so, the petition stands dismissed for non-prosecution.
I mean, the order was there.
Interim order accordingly stands vacated.
Obliged.
4 names, isn't it, Mr. Goswami? Yes, Mr. Saikya.
Not the review petition was filed by the government after lapse of more than 5 years.
Review.
Item number 18, my lord.
In this case, Dinath is coming up. After some time.
Mr. Dinath, additional senior counsel, he's there. Yes, Mr. Nath. What is this contempt? You have filed a review.
We have filed a review. The second item is the review. In the review petition on last occasion.
Mr. Saikya, you have filed your affidavit in opposition in the review.
Yes, ma'am.
You have filed.
I have filed.
No, it is possibly not filed. I have not received the copy.
Copy has not been given to Mr. Nath.
It was filed. Awesome. There are copy to issue.
All right, you give him a copy, Mr. Heard Mr. R.C. Saikya, huh?
It is possible. Online I have checked. It is not reflected in the online.
Now review to some. Yes, there is even I don't have in my file, Mr. Saikya.
My lord. Affidavit is not there, my lord.
No.
So maybe my lord directed to place the affidavit.
Mr. R.C. Saikya, Leonard Senior Counsel, appearing on behalf of the petitioner in you're appearing in the review also, no?
I'm appearing on against the review, my lord.
He's appearing. Petitioner in contempt case number 87/2020 and for the respondent in the review petition, correct, Mr. Nath?
1, 2, and 1.
And for the respondent number?
1, 2, and 3.
1, 2, and 3 in the
review.
review petition submits that an affidavit in opposition has been filed against the review petition. However, the same is not available on record.
I have given.
Let registry verify and place the same on record. Mr. Nath also submits that a copy has also not been furnished to him. Let a copy be for Mr. Saikya through his junior has furnished a copy of the affidavit in opposition to Mr. Nath in the court itself. I'll relist after 1 week on a date to be fixed by the registry. With the affidavit in opposition filed by Mr. Spencer. Assisted by, have I said? Leonard Senior Counsel. Huh? Senior Counsel assisted by MS?
Junior number.
Assisted by? Arbharali. Mr. Saikya, anything else?
My lord, that you will go outside Assam Either it may be listed, my lord, in the last week of this month of June or the first week of June.
First week of?
First week of June. Last week of June or first week of June.
You are not going to be there in
I'll be
between.
going after 7. After 7, I will go, my lord.
When do you want to tell me? You tell me when you want, I'll fix it.
My lord, on 26 June.
All right, 26th June.
Obliged.
My lord, the connected appeal was dismissed for non-prosecution. I have accordingly filed an application for readmission of the appeal, but while filing that application, there has been some delay.
265. This IA 555 is what?
For condonation of delay. So a notice may go at this stage, madam.
The delay is 265 days.
Yes,
Delay is 863 days.
860.
863.
Notice has not gone till now.
So this is the first time it has been listed after being filed, my lord. It was filed in 2020, but
This is filed for, the condonation is for filing what?
for an application for readmission of the appeal.
Restoration.
Yes, right.
Uh,
In fact, for appeal, it is the term used is readmission of the appeal, Order 41, Rule 19.
Yes, much back. Issue notice. You are Mr. Das appearing.
ASIDC, my lord. Still
Huh?
also ASIDC.
I respond number 3.
3.
Issue notice, Mr. S. Das, learned counsel appears, accept notice on behalf of respondent number 3 and 4. No, only 3.
Only 3 and 4.
3 and 4. Sure, na? 4
Yes,
is
yes.
small scale in
Small.
huh?
Three.
3 and 4. Steps in respect of 1 and 2 by registered post AD within a period of 3 days. And before that, you say extra copies within 3 days, huh? And list after 3 weeks and a date to be fixed by the registry.
Value.
My lord, in this matter, my lord, state has to ascertain service of notice, my lord.
My lord, here, as per office note, my lord, we have received the, my lord, copy of the, my lord, petition, my lord.
You have received the report.
Not report, not yet. We will have to ascertain, my lord.
So you ascertain it. Mr. P. Sharma, learned APP for the state respondent submits that further time may be he's still awaiting
My lord,
to
everything.
receive the report from the jurisdictional police station as regards the service of notice upon the informant.
My lord.
My lord, I want to clear one thing, my lord. The opposite respondent number 2 is residing under Tolamara police station, but the case was registered in Dipu police station, my lord. My lord, might
You
be because
inform
of
the
that.
police.
My lord, I will inform.
You inform,
My lord.
get it from them if
My
need
lord.
be.
I will inform telephone again.
Yes. Relist after 2 weeks
My lord.
My
on a
lord,
date to be fixed by the registry.
My lord.
my lord, kindly fix a date, my lord. You already 3 years over, 4 years conviction is there, my lord.
Yeah, date.
Oblige, your lord.
18 June.
Oblige, your lord.
All right. Why is this RFA for orders?
Lordship, the RFA is already been admitted. The respondent side has also appeared, Lordship. Thereafter, what happened on Lordship 2/8/2023, the learned court sent the record to the district and session judge court due to pecuniary jurisdiction. The respondent, learned counsel for the respondent paid, and accordingly, the appeal was transferred, sent back to the additional district
For
judge court
disposal.
for disposal.
And this present appeal stands closed. Appeal was closed.
Lordship, the position is that because of the pecuniary jurisdiction of 20 lakhs, the
But tell me one thing, this RFA, it appears there is a judicial order that the present appeal stands closed.
No, reason behind that first set is that because after closing of this appeal, because this was not proceeded before this court, by virtue of the order out of which this matter was remanded back to the learned court below, additional district judge. But afterward, since there is a notification of 20 lakhs, the learned additional district judge again remanded back to this honorable court for further persuasion.
Where are those?
That order is there, online order is there. That has been enclosed with the case record.
So, but Mr. Samurai,
Last part of the file enclosed.
my difficulty is if we see 2823 order,
Yes.
it appears that the RFA has been closed.
Yes, my lord.
Closed means what? Disposed of?
No doubt, my lord. That meaning there was
Correct.
some, but let us understood in that way that
No,
because
but no, that is the only way to understand.
now let's see if suppose for a moment we treat that it has been closed, but since it has been on by virtue of that order remanded back.
Now, in that case, perhaps the registry will have to re-register it or do something. How have they listed this?
Lordship may pass necessary directions to make it regular. No
I think let it have this on Monday. Let me call the registry and find out
No.
what is to be done, because this doesn't appear correct.
Yes, my
Let
lord.
us
The
not.
petition is little bit required to be regularized.
Yes.
No,
Of course, we will have your appeal, but
he will be sufferer otherwise.
yes, tomorrow you should not suffer.
Yes, Lord.
So let us
We want the
regularize it.
Yes, the matter has to be tested on merit.
If you go by this order, it appears your
Quite-
appeal stands closed means what? Disposed
Quite-
of. As far as,
yes,
as
according-
far as RFA 8 of 2023 is concerned.
Yes.
Yes, ma'am.
So maybe now after receiving back, it might have to re-register it or some
Lordship
order.
may
Lordship, can
kindly,
it be done this way?
readmit
Direction may be given to the registry to suppose renumber it in a fresh way, and based on that manner, the matter may be taken up by this honorable court. And lordship, so far the admission part is, as my learned friend is saying, it has not been admitted till yet.
Yes, no.
It is in the admission column.
Lordship, by order dated 9/5/2023, the matter has already been admitted, Lordship.
Only stay was granted in
No.
respect of.
Lordship,
No, please, you see, Mr.
order
Kaushal,
dated
I'm not on all
9/5/2000.
that.
Sorry.
I'm not on all that.
Yes, yes.
As of now, this RFA stands closed means what? It is already disposed
Dispose
of.
of.
Now we have to put it back to the file. Either because there is no application for restoration, it may not be done in this manner.
Yes.
Perhaps it may have to be re-registered or something. I need to be sure of what is to be done.
Lordship may
Hey,
readmit
lordship,
the appeal.
include, no problem.
Readmit the appeal, Lordship. Lordship may.
Better to re-register it, my lord. I think that will serve the purpose.
There is an order. No, it's already done.
Already admitted, Lordship. No past derivation.
The matter is placed before the Honorable Chief Justice, and his Lordship is pleased to order the restoration of the above referred case and for listing before the Honorable. That is done.
Yes, ma'am.
In terms of the above, they have done it. It is as per order so and so necessary steps may be taken for restoration. But thereafter, what has happened? Otherwise, it has to be fixed for hearing, no?
Yes, yes, Lordship.
Lordship, may I pray one thing?
1 second, Mr. Samar. All right, please take down. Heard Mr.
UB Sharma.
UB
Sharma.
Sharma, also heard Mr. S. Amurai, Learned Counsel appearing for the respondent. It appears that this RFA, which was earlier closed by order dated 2/8/2023, in view of want of pecuniary jurisdiction,
Yes, Lord.
has been returned back from the Additional District and Session Judge number 1, Kamruk M, as suit value is found to be more than rupees 20 lakh.
Yes, Lord.
Stop. It further appears that upon receipt of the case record, the matter was placed before the Honorable Chief Justice of the Guwahati High Court in the administrative site, and the matter thereafter was restored to its original record, i.e. RFA 8 of 2023. Accordingly, the matter has been listed before this court today. It appears that the appeal has already been admitted.
Lordship, can you see for a moment order dated 2/3/2020?
Admitted by order dated 9/5/2023. It further appears that the case records has also been received. Matter is ready for hearing. Let the matter be posted for hearing on.
Usual course, Lord.
My lord, not
Tell me.
My lord, next Thursday, my lord. We are
Not next Thursday, in the month of June, on a date to be fixed by the registry.
Better maybe kindly send in usual course. It is 20.
My lord, why he wanted, he's a
Next.
he should dispose it as early as possible.
Next matter.
Highly obliged.
May it please your lordship.
Yes.
Lordship, may be pleased to see the affidavit filed by the petitioner matter.
Affidavit filed by?
The petitioner matter.
Is a criminal petition.
Lordship. Thus the service was allowed, and lordships, the opposite party, number 2, my lord, he refused to take service.
Accept.
Yes, lord. Paragraph 2 may be seen, my lord.
Paragraph
2 of the affidavit matter.
You will appoint someone for R2 then.
Lordship.
The criminal appeal, criminal petition.
Criminal petition.
Third, Mr. P.K. Garodia, learned counsel for the petitioner. Also, Mr. B. Sharma, learned APP for the state respondent. Office note dated 28/5/2025 indicates that notices have been issued to the respondent number 2 by registered post with AD and by dusty mode of service on 25/4/2025 respectively. However, neither AD card nor any unserved notice has been received back by the section till date. It further appears that an affidavit in relation to dusty service of notice has been in respect of respondent number 2 has been filed by the petitioner. A perusal of the aforesaid affidavit of service indicates that though the counsel for the petitioner had taken dusty service upon the respondent number 2 on 27/5/2024. However, he refused to accept the service of notice despite being requested. Hence, service is deemed to be completed. This being a criminal petition for quashing and setting aside the proceedings in CR case number 811 of 2022 and the order dated 10/5/2022 passed by the Court of Learned Subdivisional Judicial Magistrate 2 Kamruk Metro, taking cognizance of the offence under section 138 of Negotiable Instrument Act 1881, this court deems appropriate to appoint a legal aid counsel list funding to represent the informant stroke respondent number 2 in the matter. Any empaneled legal aid counsel is present in the court? Or amicus curiae, empaneled amicus curiae? You are there, Ms. Chaudhary?
Yes.
I'll appoint you. You are legal aid or amicus?
Amicus.
Amicus. Accordingly, MS R. Chaudhary, right?
Lordship.
R. Chaudhary, learned amicus curiae is learned empaneled amicus curiae is appointed as an amicus curiae to represent respondent number 2 in the criminal petition. Let a copy of the criminal petition along with anything else is there?
No.
Only just criminal petition, huh? Be furnished to MS Chaudhary, learned amicus curiae within a period of
3 days, my lord.
3 days from today. Yes, when should we list it?
Lordship will list it after 2 weeks, my lord.
2 weeks, Ms. Chaudhary? Relist after 2 weeks on a date to be fixed by the registry.
Okay.
Let the name of MS Chaudhary, R. Chaudhary, learned amicus curiae be reflected in the cause list by the registry.
Okay. Oblige, man.
May I please, Your Lordship? Lordship, I am placing an IA, Your Lordship. The petitioner is in jail, Your Lordship.
May I submit prior to his submission, Lordship? Lordship, here in this case, Lordship, earlier NJ does as Amicus curiae appointed, Lordship. But Lordship, today his name is not shown in the cause list, probably that is why he is not present, Lordship.
Monday?
Look.
It appears that the name of Mr. N.J. Das, learned counsel, appearing as an amicus curiae, appearing for respondent number 2 stroke informant is not reflected in the cause list. Relist Tuesday or Monday?
Any date, Your Lordship.
Relist on Wednesday. Showing the name of Mr. N.J. Das in the learned amicus curiae for respondent number 2 in the cause list.
May I please before Your Lordship? Lordship, this is an introductory application. There is a continuation of delay. Delay is around 230 days.
First time?
Lordship.
No, this has come for the first time. No,
Lordship, impugned order was passed on 14/8/2020. I am for the sole respondent, my lord. Its matter relates to 125, my lord. It's a
Maintenance,
maintenance case, Lordship.
Any objection?
Well, I have serious objection, my lord. I have filed it, my lord.
You file affidavit.
Already filed, my lord. Let her submit, my lord, then I.
Yes, what is the grounds for delay?
Lordship, I like to draw your attention to page 6, paragraph 7. The applicant was totally unaware of the same since the advocate, who is the legal aid counsel, appeared on behalf of the applicant, did not inform the applicant about the passing of the impugned final order
Page
against him.
6, para?
Para 7, Lordship.
Yes. This is the 696 IA. IA number is 696.
Yes, Lordship.
Yes, read para 7.
That the applicant begs to state that impugned final order dated 14/8/2023 passed by the learned judicial magistrate first class Bongaigaon in Miss case number 7 of 2022, but the applicant was totally unaware of the same since the advocate, who is the legal aid counsel, appeared on behalf of the applicant, did not inform the applicant about passing of the impugned final order against him. Thereafter, the applicant came to know from a reliable source about passing of the impugned final order and accordingly applied for the certified copy of the aforesaid impugned final order on 2/5/2024 and received the same on 6/5/2024. Thereafter, the applicant, after gathering the necessary money, came to Guwahati and engaged an advocate who took few days to prepare this criminal petition and filed the same on 12th June 2024. And same was withdrawn due to some technical irregularity and a fresh application was filed.
Just go slow, Miss Counsel. You're going very fast.
Sorry, Lordship.
The order is of 14/8/2023. was unaware and did not inform, and ultimately applicant came to know. When did you come to know?
I came to know on 2/5/2024.
2/5/2024. That is after how many days?
Lordship, there is a delay of 230 days total.
No. Between 14/8/23 and 2/5/2024.
August, September, October, November, December. It's around 9 months, Lordship.
9 months. Now, how did you know? How did you come to know that you have not said reliable source? What is this reliable source? Because you see why I'm asking you this. Come to know after about 9 months. Are you
Lordship, initially, the advocate from legal aid was appearing in
all right, but your source of information, your source of knowledge is material here. How did you come to know? What is this reliable source? That is not disclosed. You have not disclosed. All right, further continue then, and you received it on 6/5/24. Now, what did you do after that? You arranged for your money. Then you engaged an advocate. Then you took few days to prepare. And ultimately, you filed it on
12/6/2024. And since there was a technical defect in the petition,
That
so
is
there
all
was the
right, but
order
you
to
have-
file a fresh application, Lordship.
Acha.
And it's a maintenance case, Lordship. The respondent claimed 4,000 for herself and 3,000 for her minor
No,
son.
but then, ma'am, what is this reliable source? You have not disclosed. Yes, where is your objection?
My lord, before the my lordship, my lord, in para, sole ground is my lord, legal aid counsel did not inform him, my lord. My lord, absolutely wrong statement before the bar, my lord.
Why?
My lord, I got the certificate, obtained the certificate copy. Jackson, I'm traveling, my lord, for a moment, my lord. Your lordship, start from the 2010-2022, my lord. First order, both parties are duly represented. Second party has submitted written statement, that is the petitioner, husband. Copy of the written statement will be furnished to the petitioner, fixing evidence as. Next, my lord. First party is present, first party has submitted evidence such and such and such, copy of the same submit. Second party is absent with the step, white petition showing cause, hard petition is allowed, fixing for cross-examination. Then 23/12 then both
You
parties.
are appearing for the
Wife. Both parties are absent with petition number such and such, hard petition and allowed for cross-examination. Then 2/2/2023. First party representing along with two witnesses. Second party has filed petition such and such, praying for another date for appearance. Hard
first party is you.
in the court below first party is me and the wife. Hard period is allowed, sin petition such and such file kindness second party, praying for another date for cross-examination of PWs. Hard considering the ground shown, prayer is allowed with cost 300 rupees to pay to the next day. Fixed 23/2023 for cross-examination. Next, my lord, on 23/2/2023,
Absent
first
without
party is
step.
absent with one witness, is present with one witness.
Party
Second
absent
party
without
is
step,
absent
ex
with.
party.
Hence, the should proceed ex parte.
23 again, then the arguments.
Then arguments. Then, my lord, first party is asked to furnish, my lord, as per episcopal judgment, my lord, the asset, other things. First party hasn't again represented. However, none has repented, called for on behalf of the second party, learned counsel party direct to submit incomplete affidavit as per formal before this honorable court, next date fixed. Then final order 26/4/2023. Last matter. Petition is present through engaged counsel, no affidavit declaring asset, liability submit to date by the petitioner as per order dated. Petitioner submit affidavit declaring asset liability on the next date fit without fail, fixing such and such. 17/5/2003. Petitioner is present through the engaged counsel, file affidavit on declaring asset and liabilities. For final argument, then 6/6/2023, petitioner is present through engaged counsel, hard language counsel for the appearing for the petitioner, fixing for final order.
So
Then,
after that date,
question of engaging legal aid counsel does not arise, my lord. He contested the case. Thereafter abstained from attending court. Court pass an ex parte order hearing, then continue proceeding, and final order pass. So absolutely, this is a wrong statement before the bar.
And all throughout, the second party was representing himself. There was no
Earlier.
counsel.
No, through counsel.
Through counsel.
Through counsel, 2-3 occasions. Then remain absent at his choice. So therefore, this honorable court below has passed ex parte order, then proceed and ultimately final order pass.
Now let us come back to paragraph 7 once again at
My
page
lord.
6. You read.
That the applicant beg to state that impugned final order 14/8/2023 passed by the learned council, learned judicial magistrate first class, Bongaigaon in such and such, but the applicant was totally unaware of the same, since the advocate who is the legal aid counsel appearing on behalf of the applicant did not inform the applicant about the passing of the order. Well, where is the question of the legal aid counsel
This
information?
counsel, you see, it appears that very wrong informations have been averred in under oath.
Yes.
Because the fact that you have stopped appearing, the fact that your counsel have stopped appearing, these are not disclosed before this court. The order sheet speaks. It loud. You are
Lordship, may I pray
representing.
for one thing? Lordship, may I pray for one thing? Can supplementary affidavit be filed regarding this?
Sorry?
Supplementary affidavit can be filed?
No, no. What supplementary affidavit you will file?
It is,
The
Mala,
order
it
sheet is
should
there.
be cost
Uh,
with, it should be
This
dispatched
is
with
not,
cost.
you see, condonation, delay condonation is a discretionary power of the court. When a party come before the court, it is utmost important that the party comes with clean hand. The grounds has to be sufficient, plus it has to be bona fide. This is not a bona fide ground. You have not even disclosed that you have stopped appearing. Not only you, your counsel. And then you are saying that your legal aid counsel has not given. Where is the legal aid counsel? Who has appointed the legal aid counsel when you had your own counsel? All right, it could be that your counsel stopped appearing. After you came to know, you would have to look into it. Then you would have to tell her that you were never informed about the date. Where are those explanations? On the other hand, you have given a contrary statement. You have misguided the court. And you have not even disclosed the source of information through which after 9 months you have come to know about this order. How you have come to know about this order? Sorry. No case is made out.
Kindly fix the shorter. Let me
Sorry.
come and do this matter, Lordship.
No ways.
Lordship, let my senior come and place his submission. Lordship, kindly fix the short date,
No,
Lordship.
my lord, 2023, my lord, maintenance has not been
None of
paid,
take.
my lord.
This is item number.
25, my lord.
25, Lordship.
Your name? Your name.
My name is Devasri Chakraborty. Lordship, my senior is out of the number.
Miss Counsel, this is a court. Please have some respect. You have been arguing the matter just when an adverse order is going to be passed. You cannot come up with the submission that now please do it, let my senior come. This is not the way
As
one
your lordship.
appears before the constitutional courts.
As your Lordship, please.
Heard MS, your name.
D. Chakraborty.
D. Chakraborty, learned counsel for the applicant. Also heard Mr.
A.K. Hussain.
A.K.
Hussain.
Hussain, learned counsel appearing for the respondent. This is an application under Section 5 of the Limitation Act 1963 for condoning the delay of 230 days in preferring the criminal revision petition. Stop. The brief facts of the case is that the respondent stroke first party filed a petition under Section 125 CRPC before the Court of Learned Chief Judicial Magistrate Bongaigaon on 8/2/2022, claiming total maintenance of rupees 20,000 per month for her and her minor child from the applicant, which proceeded in the Court of the Learned Judicial Magistrate First Class Bongaigaon in miscellaneous case number 7 of 2022. Stop. In the said case, by final order dated 14/8/2023, the learned jurisdictional magistrate disposed of the maintenance case by directing the applicant to pay a sum of rupees 4,000 per month towards maintenance of the respondent stroke first party and rupees 3,000 per month towards their minor son. Aggrieved by the aforesaid final order of maintenance, the accompanying criminal revision petition has been filed. However, while filing the aforesaid accompanying criminal revision petition, a delay of how many days?
230 days.
A delay of 230 days have occurred, for which the present condemnation application has been filed. MS so-and-so learned counsel for the petitioner submits that the legal aid counsel, having not informed the appellant, the applicant, as regards the passing of the final maintenance order, the delay has occasioned, which is beyond the control of the applicant, and hence the delay be condoned in the interest of justice. Per contra, Mr. So-and-so Hussain, learned counsel for the respondent, submits that the applicant has tried to mislead this court by making false averments under oath to the effect that the legal aid counsel of the appellant has not informed the applicant as regards the passing of the final order, when it is discernible from the order sheet of the jurisdictional magistrate's court that the applicant was represented by his counsel before the maintenance proceedings. And when did they stop appearing?
My lord, 23/2/2023.
After and after the
Filing WS.
and after filing the written statement, both the applicant as well as the applicant's counsel stopped appearing before the maintenance jurisdictional magistrates court since 23/2/2023, for which the matter proceeded ex parte and finally was concluded by passing the aforesaid final order. Hence, he submits that this petition, this application for seeking condonation is not bona fide and is liable to be dismissed with cost. Heard, perused. It appears that the grounds of 230 days in preferring the accompanying criminal revision petition, as stated in the condonation application, reads as hereunder, quote unquote, paragraph 7. Hello? It appears that reading of the aforesaid paragraph, it is clear that the only ground urged is that the legal aid counsel failed, having not informed the applicant as regards the passing of the impugned final maintenance order. He, having come to know later on, had taken steps to file the criminal revision petition, for which there has been a delay, wherein a delay of such and such day occurred. It appears that though it has been said that the applicant came to know from reliable sources about passing of the impugned final order, which is approximately, which is almost after 9 months of passing of the final order. The applicant has not even bothered to mention in the aforesaid pleadings as regards the source of the, as regards the disclose the source from whom and how the applicant has come to know about the passing of the final maintenance order. That apart, the order sheet of the maintenance case of the maintenance case of the jurisdictional magistrate court, which has been a certified copy of which have been placed before this court by Mr. Hussain, learned counsel for the appellant, respondent, which is kept on record and marked as A, indicates that the applicant has appeared before the maintenance court along with his counsel and has also filed his written statement. It further appears that from 2010-2022, the applicant, along with his counsel, appeared on the subsequent dates and has also participated in the maintenance case. However, from 23 to 2023, both the applicant as well as his counsel stopped appearing before the magistrate court, for which the matter proceeded ex parte against the applicant. Ultimately, the final order was passed on. The final order is 14 something.
14/8/2020.
14.
14/8/2020.
Ultimately, ultimately the maintenance order was passed on 14/8/2023. 2023. Stop. Undoubtedly, the power of this court to condone delay is discretionary. The power of condonation cannot be exercised as a matter of course. It is condition precedent that sufficient and bona fide ground be shown before the court exercises the aforesaid discretion in favor of the applicant. In the present case, it is apparent that the applicant has not disclosed before this court the correct facts, which is now established from the order sheet of the magistrate court. That being so, it is apparent that the applicant has not been bona fide and the grounds averred are not sufficient. Accordingly, the condonation application stands rejected. Yes, cost, no cost.
Grateful Lord.
Disposed of. Yes.
Lordship, due to some personal difficulty of my senior, I may be given an accommodation for today. Lordship,
All right. When do you want it?
Next week, I have already.
Your name?
P. Agarwala.
P. Agarwal. MSP Agarwala, learned counsel, appearing for the applicant, seeks a short accommodation on the ground of her senior, on the ground of her senior having personal difficulty today. Prayer is not opposed. Relist, yes, when? My lord, next week, my lord. All right, relist after a week on a date to be fixed by the registry.
My lord, another exhibition, my lord, I have filed an affidavit in opposition that is not in record.
You have filed?
Yes, already filed on 26, my lord.
Where? In the IA?
In IA, my lord.
Acha, Mr. So-and-so further submits that an affidavit in opposition has been filed in the interlocutory application. However, the same is not on record. Let registry verify and place the same on record.
By document number 3, my lord. Published.
I think in the morning you wanted some accommodation here.
Yes, lordship.
Paper book is ready? No. The records have come. Swasan? It appears that the records have been received. This is a jail appeal, no?
Yes, lordship. Yes, lordship.
Jail appeal? No, you are a private counsel, you're not an amicus.
I'm the appellant, lordship.
So then, paper book at his cost, right? Where is the APP gone? You're there. Paper book will be at his cost, correct? Let registry prepare a paper book at the cost of the appellant, and upon completion of the paper book, the same be furnished to both the counsels appearing for the parties, and list the same before the court.
Obliged, lordship.
You bear the cost of the paper book. Why is this for orders?
Lordship, I was previously told to text steps on the respondent number 2.
Have you taken?
Yes, Lordship. Lordship, records were called for.
But still, it has not come. This is what are
Lordship, in the cost list, it reflected with LCR and case diary.
That is all right. Then why are you saying records be called for?
No, Lordship, on the previous order, Lordship. As on the previous order, Lordship.
Mr. Sharma, you're appearing in this. You're appearing in this matter. No, it seems that the AD card is still not, or unserved notice is not back from.
If your Lordship may kindly peruse the order dated 28/4/2025, Lordship.
20?
28/4/2025.
Yes, I have seen that order, but after
Yes,
this
Lordship,
order.
in para 7, it is stated that.
CD part was called for last portion, my lord, last para, my lord. Here,
Lordship, the respondent number 2, he was serving as an police in Silgat police station, Lordship, during the time of filing the FIR. So he's also part of the police officials, Lordship, of the concern.
You have the case diary?
No, my lord. Scan copy of trial court record was called for, my lord.
That I think has come.
Yes, Lord.
No, but the difficulty is the service in respect of R2.
My lord.
It's not complete.
Not complete,
I
my
think
lord.
we can wait for some time.
My lord, my lord.
Await service in respect of respondent number 2,
my lord.
list after 2 weeks on a
My
date to be fixed by the registry.
Lordship, I may be granted some interim protection.
No,
Lordship.
no.
Proceedings are going on. Even there is no prima
Where is the
facie evidence,
FIR?
Lordship.
Where is the FIR?
Lordship, FIR is on page number 10, Lordship. FIR is page number 10.
This is for quashing the FIR.
Yes,
my
Lordship.
May I please, your Lordship? Lordship, item number 5, IA number 560 may be taken up first, Lord. IA 560 may be taken up first, Lord.
560?
560.
560.
560. I mentioned it in the morning, Lordship. The court was called for.
Yes. What is this?
Yes, this is for bail, Lordship.
For?
Bail. That's because during the pendency of this case, Lordship, he was arrested and put behind the bar.
It has come.
Oh, my lord, here what happened, my lord? He was convicted under section 326, my lord. 1 year conviction, my lord. And they filed one petition for suspension, my lord. On that occasion, the court lordship was pleased to call for a record, my lord, as it was already dismissed by the appellate court also, my lord. Therefore, they have filed. In the meantime, my lord, he was arrested, my lord.
So that's why the bail.
My lord, that's why they are directed to file an IA, my lord, for bail, my lord.
Now
1
what-
year conviction, my lord.
Can we take it up?
My lord. Otherwise, my lord, here also notice.
There's only 1 year conviction.
1 year.
1 year conviction.
And
Already
during
he's-
the stage of trial, were you on bail?
I was on bail, but during the pendency of
Well,
this,
not
we
this-
have not, previous bail. Then I mean, it may be granted, Lord.
But
40
now
days
you have
behind the
been
bar.
already arrested.
Arrested,
Yes,
my lord.
now 40 days behind the bar. Lord.
How many days?
40 days.
40.
40.
So one is for bail and one is for suspension.
The another 40 thing is,
My
it is in fact
during the
suspension.
pendency and the suspension of the petition, my lord, he was arrested, my lord. That's why they filed that IA.
So I'll take up the IA. I'll
My
dispose
lord,
it
my
of
lord,
the-
my lord.
এইটো IA হেৰিত পিপা
Suspension
560 of 25 তুমি গোটেইটা ডিসপোজিট পাই আছা নেকি এতিয়া হা এইটো কৰিব পৰা নহয়
1 বছৰ ন 1 year.
1 year. এইটো নালাগে এতিয়া।
সেইটো নালাগে আৰু suspension নালাগে।
নহয়, এইটো suspension থাকিব। মানে এইটো নহ'লে আকৌ এইটো যাব। suspension থাকে।
মানে বিলটো দিব।
Anything?
No, no.
No,
Heard Mr.
KK Hendik, Lordship.
KK Hendik, learned counsel for the applicant. Stop. Also heard Mr. B. Sharma, learned counsel, appearing for the learned EPP for the state respondent. When there are writ petitions, civil petitions, criminal petitions, I'm now getting confused.
One petition, another civil petition.
This is an application under section 483 of the BNSS 2023 seeking granting of bail to the petitioner, i.e. Sri Nagra Brahma alias Boro, who was arrested on 21/4/2025 in connection with GR case number 9240/2011. The brief facts of the case is that the petitioner, the applicant accused, was convicted under section 326 of IPC in connection with the above noted GR case number 9240 of 2011 by the jurisdictional chief judicial magistrate court by judgment and order dated 8/2/2024. And he was sentenced to undergo rigorous imprisonment for 1 year and to pay a fine of ₹2,000 only, and in default to undergo simple imprisonment for another 1 month. Situated thus, the applicant accused preferred an appeal before the Session Judge Kamrup M at Guwahati by criminal appeal number 24 of 2024. Wherein the learned appellate court by judgment in order dated 4/3/2025 uphold the sentence passed by the Chief Judicial Magistrate Court. Order to date দিয়া হল না appellate court orders date দিল না judgment in order dated court. Thereafter, the applicant accused preferred a criminal revision petition before this court, criminal revision petition number 117 of 2025, wherein this court was pleased to issue notice and call for records. Stop. During the pendency of the aforesaid criminal revision petition, the applicant accused was arrested on 21/4/2025 by the Gorchuk police station on the strength of warrant of arrest issued by the learned trial court, and accordingly he was produced before the learned court of CJM Kamrup Metro, and upon production he was remanded to judicial custody. Stop. Since then, he has been languishing in the judicial custody. Stop. As accordingly, the present bail application. the interlocutory application for seeking bail pending the criminal revision petition. Hmm. Mr. So-and-so, learned counsel, Hendik, na? So-and-so Hendik koriba. Learned counsel appearing for the petition, applicant submits that since the petitioner has all along during the stage of trial was on bail and has participated in the trial without hampering the trial, he may be released on bail pending adjudication of the criminal trial. Mr. So-and-so Sharma, learned APP, submits that it appears from the petition that the applicant has cooperated with the investigation and has also appeared before the trial court at all stages and has not done anything to hamper or to hamper or to threaten the witnesses during the trial. He further submits that there is no criminal, there is no adverse antecedent as available on record against the applicant. Heard, perused, over. Considering that the conviction is under section 326 IPC for sentencing the applicant for a period of 1 year. Along vis-a-vis that the petitioner, that the applicant has not participated duly during the trial without hampering the trial. This court is of the view that pending adjudication of the criminal revision petition, the petitioner be allowed to stay on bail. Condition any?
My lord, condition is required, my lord.
Subject to condition?
His bill, my lord.
Subject to condition?
Surety apply or
Surety to agote DT. It is accordingly provided surety of
20,000.
10,000.
10,000.
10,000. One surety.
Like amount.
Like amount. Satisfaction of?
Trial court below. CGM Kamrup.
CGM Kamrup M. I think that is all what disposed of.
I disposal.
I 560 disposed.
Another I 403, that is infractions as because we have preferred the bill under wrong provision of law. 403.
So in 403 Kuba, that
is infractions.
Mr. So-and-so Didiba and Mr. So-and-so Hendik submit that this interlocutory application in the meantime has become infructuous. And in fact, as such, the IA stands dismissed on being disposed.
Another I 331 Lordship.
331.
That is suspension of bail conviction.
Yes.
Suspension for conviction.
That this is an application under section 430 of the BNSS 2023 preferred by the revision petitioner for suspension of sentence pending disposal of the criminal revision and release of revision petitioner on bail. Pertinent that pending the aforesaid criminal revision petition and the present interlocutory application for suspension of the aforesaid sentence, the applicant was arrested, for which an interlocutory application for releasing the applicant on bail has been preferred to this court by order dated so-and-so agitated was pleased to allow that interlocutory application by allowing the applicant to remain on bail, to be on bail, release on bail. Stop. The grounds of, where are the grounds mentioned here?
No, Lordship, in the revision I have read it down.
Here you have not mentioned.
It was on para number 9 that the petitioner basis that he was on bail during the trial and he has
No,
given.
not that. In the suspension, what grounds have you mentioned?
In 10, the petitioner beg to state that there are good grounds for revision petition and there is every likelihood that conviction and sentence of the petitioner will be interfered by this honorable court. And grounds have been inscribed in-
Peruse the grounds ever for suspension of so-and-so and all, and considering that so-and-so has already been granted bail by keeping the sentence by keeping the period of sentence imposed by the trial court, this court. Actually, even if I don't dispose this also is not necessary. You are already released on bail.
My lord, already released on bail.
Because if I have to
My lord.
dispose this, I'll have to dispose it on merit.
My lord.
It will list
Not necessary.
this and the main criminal petition, both you say just simply say list after 2 weeks
My lord.
or a date to be fixed by the registry. Duta dispose you say it no. Yes, next.
Deeply obliged.
Yes, Mr. Chaudhary.
Yes, my lord. Lordship, first your lordship kindly peruse the order dated, my lord. 9/4/2025 and 10/4/2025.
Criminal petition.
Criminal petition, my lord. Where this honorable court, my lord. 9/4/2025, my lord.
Yes. Mr. Bora, you are for?
I am for the, my lord. I have filed one miscase, my lord, for IA, my lord, for impleading me in this particular case, my lord.
Yes,
Para-
Mr. Chaudhary.
Para 10, my lord.
Yes.
It is para 9 form, my lord. Upon perusal, it appeared the investigating officer has clearly.
Oh, this is
said-
that
stated-
case.
Yes, my lord, during. And CCTV footage private hotel as how the
Yes.
petitioner can directed for producing the CCTV footage of private hotel where the LS
You
incident.
are
is-
appearing for that investigating officer.
No, my lord. My lord, I am for the intended accused, my lord.
It is
the
duty
accused.
of the
Intended accused, my lord.
It is duty
My
of
lord,
the.
I have filed the, my lord, that may be taken up first, my
One
lord.
second, I'll
Yes.
come
It
to
is,
that.
it is duty of the investigating officer to
Okay.
collect the evidence, thereafter submit report. Before proceeding the matter, appropriate so-and-so learned counsel, so-and-so, PS locker, so-and-so. Then matter was fixed on next date, my lord. 10/4/2025, my lord. On next date, my lord, your lordship kindly come to the order, my lord. 10/4/2025. Heard Mr. So-and-so, learned counsel for the petitioner, PS locker, so-and-so. Pertinent on 9/4 to the after hearing the learned appearing both the party, court noticed the investigating officer submitted the affair without collecting the CCTV footage of the place of occurrence. However, before proceeding further in the matter, court deemed it appropriate to direct the additional public prosecutor to produce the case record from the jurisdiction police station. Today, when the matter was called.
Yes, I've read it.
Yes, madam.
Now, what happened?
My lord, it could come, you also come with this line. It prima facie appeared that FR has been submitted by the investigating officer without collecting the CCTV footage from the place of occurrence. Hence, the impugned order dated 4/3/2025 passed by the Judicial Magistrate Kamrup Metro shall remain still till next date. Mr. Boyddo, learned counsel appearing sought permission to address
I've
the
read
court.
it,
on-
Mr. Chaudhary. I'm sorry, but I've read it.
Yes.
I read it a little faster. So Mr. Vaidya had submitted that it is not obligatory for him for the accused
Yes,
to
my
be
lord.
made a party, but
Yes.
however,
Yes.
participatory right, and
Yes, ma'am.
this is why this court says, be that any as it may, liberty to participate in the proceedings.
They can participate.
Yes, I've read it.
Now, my lord,
But
this.
what has happened to the subsequently the CCTV footage has been brought or not? Who?
No, my lord.
It is
let-
unto the
let
public.
me-
Mr. Bora, 1 second. You take your seat for the time being.
My lord.
Yes, who is appearing for the state? Who is appearing for the investigating officer? Yes, what has happened to the CCTV footage?
Let me, my lord, clarify.
Mr. Bora, I'll come to you.
Because of
You have a
this-
limited role here.
No, my
I'll
lord.
come to you.
Because of, I don't have a limited role, my lord. I have absolute legal right to represent here.
Of course,
That
we
I
will
am
come to
submitting-
that, but
because
let me
that-
find out from the investigating officer first, as regards the query of the court, as what has happened to the CCTV. This
That-
court has been repeatedly asking
Yes,
for
my lord.
production of
But
the
that is
CCTV.
whether that is the correct proposition, my lord. Let me, that's why I'm saying, my lord, before going into that aspect, my lord, that CCTV
One
related.
second, let me
Yes.
first hear Mr. Chutia. I will come to you, Mr. Bora. You take your seat. Be patient. Yes.
Is 91. The Zafran Nagar, that has been paragraph 9, madam.
Page
91.
yes.
Paragraph 9.
Yeah.
In his report, the IO has mentioned that he has examined all the available witnesses and got their statements recorded under section 1 CRD and collected documents including substantial agreement, collaboration agreement, and notice of these electronic devices were seized and got them examined by expert of FSL. And after evaluation of all evidence, including oral, documentary, and digital evidence, it was found that in addition to being business partners, there was a cordial relation between the parties, and most of the communication, which has been verified by FSL, was made at the base of the victim. And it was insisted that accused to come to various places, such as Suenso, Downtown, etc., to meet during meet-part. During investigation, no potent evidence came to the light to establish the allegation brought by the complainant, but papers that have surfaced prove the case otherwise.
But where is that line where?
Para 15, my lord.
Huh?
Para 15, page 94.
Yes, I have underlined it. Para 15?
Page 9.
So
Page
far
94.
as the other allegation under section so and so of IPC are concerned, the IO has categorically stated that during investigation, he could hardly gather any material that substantiates the ingredients of the aforesaid offenses. The IO has further stated that the petitioner victim failed to provide him with the footages of the alleged assault, threat, or wrongful confinement despite CCTV cameras being installed at the place of occurrence. Now, what was the alleged place of occurrence? Radisson Hotel, Goa. Correct? Was it Radisson Hotel? No, as per the
Yes,
allegation. Mr.
My lord,
Bora, the
my
allegation.
humble submission before your lordship is that, my lord. This is the finding of the court that IO has stated before the categorically stated that.
See, Mr. Shishya,
petitioner-
I was only on this.
Victim-
I am not on anything else. You tell me, how would the victim, if suppose there is an allegation by the victim that something has happened to the victim at some five-star hotel, now can the IO tell the victim that you give me the CCTV footage of that hotel? Is it not the duty of the IO to collect that CCTV? You see, CCTV may be there, CCTV may not be there. That is a different aspect. I could have understood if there was no CCTV camera. But what is stated in this order in paragraph 15 is that the victim could not produce the CCTV.
Lordship, please allow me.
Mr. Bora, please take your seat.
But that I'm.
Mr. Bora, please take your seat. Yes,
Before that, my lord, there are two other paragraphs are also there. In those paragraphs, my lord,
yes.
that particular
All right, we will read those paragraphs.
paragraph 10, my lord.
Yes.
During the investigation, no potent evidence came to the light to establish the allegations brought by the complainant on papers that have surfaced prove the case otherwise. At the foremost, it may be noted that FIR was lost 2 days after the victim received a demand notice of Suenso from the company of the accused. The alleged offense of rape was committed in the period 2015-19. But despite that, the petitioner victim continued and maintained cordial relationship with the accused, which extended beyond her business relationship. The WhatsApp are sent by her, which has seized and verified by FSL. During the course of investigation, clearly reflects the nature of relationship which existed between them. The extended nature of relationship between the petitioner and the accused was such that it even included sharing of pictures with the accused.
This has been revealed from the inquiry.
The petitioner was has further alleged that the accused was in a position of authority
And it was for this reason she ended up having
How old was the lady? She's a she's a matured lady.
conflict with it. And it was fine.
All right. Yes, yes. Read.
The petitioner filed Alexander Spencer. He has also stated that there was a fiduciary relationship between her and the accused, but during investigation, it had come to the light from the fantasy agreement 2015 that no such kind of relationship existed between the two, and both were independent contractors with no fiduciary relationship towards each other. Again, though the picture between the stated in her statement recorded under section 164 CRPC. Then after 2018, she stopped attending all business with the accused, and she stopped having sexual intercourse with him, but our conversation takes extended with the accused dated 1/2020, the date.
Yes.
Reveals that it was she who proposed the accused that he should go abroad, and she even demanded that he should bear the expenses of her flight ticket. The mail written by the petitioner victim to the accused on 14/6/2022 reflects that she wanted to extend her intent relationship with the accused and his family. After the alleged offense filed, these are the two particular dates filed that was discussed by the minor court filer. Next, 13, on one hand, the complainant gets that is the minor ground. Victim writes a mail to the accused after the alleged rape, upon her which has been continuing for some time, and on the other hand, she come up with the allegation which is not at all sufficient to justify judicial conscience to adhere to it. A victim cannot wish her person to suit her purpose that her own sweet with. The conduct of the victim as it transpires from the materials on record in no manner supports the allegation levied by her in the FIR. The undisputed mutual exchange of WhatsApp text between the parties, which has been verified by forensic science laboratory.
All right. Today, the IA, you have filed an IA that is listed before this court today.
Yes.
But whatever you want to say to, you can always say without being
No.
formally arraigned also.
No, my lord, the
Because
formally.
this court
the
has
why-
already given you that participation.
Yes, yes.
right.
The why I-
It was on
yes,
behalf
yes,
of,
yes.
your junior had
And-
made that submission.
Yes, but
isn't it?
no, my lord, my junior had wanted to be
I think the
Impli-
submission says
implemented-
Mr. B. Vedya Learned Counsel by appearing has sought permission to address the court on behalf of the accused person, which is not opposed by Mr. NNB Chaudhary Learned Counsel for the petitioner. However, he submits that it is not obligatory to implead array the accused person.
This
in
is the
petition.
submission of the NNB Chaudhary.
Okay. Be it as it may, Mr. B. Vedya Learned Counsel is given liberty to participate in the proceedings on behalf of the accused.
Yes.
So that participation, right?
Well, participate on a formal, why I am asking for the formal participation, my lord? Because I want to file some documents before your lordship.
Can
Because,
you not bring that by way of your written submission?
no, my lord, that can be, but if the.
So I'm just trying
Yes,
to
yes.
understand because
Because the requirement of the law is that if it is a case of 40, because they have come for 480.
case of
482 petition, my lord, basically for inherent jurisdiction. But they could have come up for 401. Actually, this is because they have challenged the order of the magistrate,
closing.
rejecting their prayer, nullity petition, and closing the case, my lord.
So
They are agreed by,
been under 40?
that could have been challenged under 401.
401.
CRPC. So now, lordship kindly see what is the provisions of 401. CRPC, lordship kindly see.
CRPC.
Because in 401, it is mandatory for them to implead me as a party.
Slowly. 401.
401 CRPC. But they have very intentionally, it is not a file under section 401. 401 subsection
1 second, Mr. Bora. 401.
High Court power of revision.
Yes, please.
401 subsection 2, my lord.
Yes. Yes, please read.
Yes.
No order.
No order under this section shall be made to the prejudice of the accused or other person unless he had an opportunity of being heard either personally or by pleader of his own defense.
Let us see one first. In the
One,
case of
in
any
a case of any proceeding, the record of which has been called for by itself or which otherwise comes to the knowledge of the High Court may, in its discretion, exercise any of the powers conferred on the Court of Appeal by section so-and-so, 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 or on a court of session in 307, or when the judges composing of the
revision otherwise could have
revision,
been filed.
yes,
That is what you are saying.
yes, that would have been
filed.
yes.
Instead of filing, they've come under 482.
482. So in 482,
If it was revision, then they would have had to implead.
yes, implead me as a party.
What is
Now-
the objection, Mr.
Yes,
Chaudhary?
my lord, I have an objection.
Why?
Lordship, then in 482 also there is a judgment of the High Court, Supreme Court. There are two judgments I am relying on. In 482,
We've already given him participatory right. He
May-
wants to be
So-
formal.
let me complete.
Yes,
Then why I want to, because I just
I
want
was
to,
just trying to cut short all these contesting arguments by trying to get
And
Mr.
it-
Chaudhary
no,
concerned
because of the
with
what?
your
Yes, yes.
impeding application. I was only trying to
But
do that.
yes, yes, but that's why
Yes.
I just wanted to place two judgments of the Supreme Court in the 482 because now my right, because now when there is an FIR was there, I was an accused. When there is a final report has been tried closing that particular case, now I am a free man. Now, if they want to convert that
It affects
status,
your right.
affects my rights. So definitely when it affects my right, I have a participatory, not only, I have a legal rights now.
Because that participatory right was in context of the victims, informants and all that.
Yes.
Because that is
Yes.
between the state and the
Yes,
accused.
absolutely. Lordship,
Here, you being the accused,
originally,
Originally.
which has been now closed. So now,
all right.
because
you'll
my
be
right,
prejudiced.
yes, I will be prejudiced. That's why the Supreme Court says they have to implead me in
I
this
think
case.
I'm on this without going through the judgment also. I'm with Mr. Bora because some prejudice will be caused. Why should this court not? Because that's the basic principle of natural justice, right,
Yes.
Mr. Chaudhary? And this court has anyway, with your consent only, we had already allowed that participation. He wants to be formally impleaded,
Yes,
we'll
ma'am.
implead him.
Let me allow to submit 1 minute.
Before that, let me see the decision.
Yes,
my lord.
and just before that, one thing I
Yes.
just want to add one thing to cut short the whole entire issue, because the lordship is persuaded by the order of the magistrate that the magistrate has directed.
That is on merit. Let's not get into the
No,
merit.
this is very important issue because that has been reflected in the order, and lordship is probably persuaded by that submission. But whether that submission is correct or not, lordship has to see.
Alright.
Because my lord, this is a case, is there that impugned order based on 2 police reports. Neither of those 2 police reports is before your lordship in the petition. So wherefrom he is saying that the police is directed the victim to produce the CCTV camera of Reddition Wood, very specific. Now, there's a 2 final report already been submitted before this court, before the trial court. Surprisingly, both the final reports not before your lordship in the petition. They have suppressed those 2 final
You
reports.
want to bring all that on.
Yes, and that's one final report. I have a certified copy. It says, my lord, what lordship just before that specifically said, if it is not there, it's not there. That is what has actually happened.
Read.
Yes, my lord. A copy did here. The first final report, this is the certified copy. Actually, what happened to that CCTV case, my lord? What it was actually asked for, it's not there.
Yes, where?
Yes. Now, lordship will kindly see paragraph 16, then 3rd page, my lord. During course, it starts from.
Yes.
During.
1 second. Para 16 is a very long paragraph.
Yes, then the next page, my lord.
Next para.
During.
Yes.
During the course of investigation, the case of the statement.
This is part of what? The first report.
First report. But it was not part of their petition, my lord.
My lord,
Let
if he
me
argued on that, my lord, let me allow, but I am the petitioner.
One second.
I can
I have
understand you are
heard
the
you
petitioner, but you have suppressed the thing, that is why.
ever suppress this
Alright,
thing, my lord. I am not
please,
accept all this
since
record, my lord.
Mr. Counselor,
Without
I
making
have
that
been
statement,
hearing.
she should not make
Mr.
that type
Chaudhary,
of
I've
statement, my
heard you
lord.
also patiently. He
How
wants
can
to
he
make
say,
a
my lord? He
submission, I'm
access all these
hearing.
things, my lord.
All
You
right.
can allow the petition for
Mr.
I-
Chaudhary,
all
Mr.
that
Chaudhary,
word should not be used, my lord,
Mr.
suppress, my lord.
Chaudhary, please maintain the. Please
Because
be calm. Please be
they-
calm.
they-
Yes, Mr. Bora,
Yes.
please
Yes,
confine yourself only to the report.
yes,
Let
during
us
the
not
course
get
of
into
investigation, because
other,
these,
things.
because this is a very final, my lord, this is the come up because your lordship has categorically in the order has stated so. That's
Very
why I'm
well,
coming.
you just
Yes,
read this.
61 statement. In the course of investigation, no evidence has been found against the alleged accused Ajay Bansal regarding the sexual harassment of the complainant. As stated by the complaint statement of 164 CRPC on 11/10/15, Ajay Bansal called complainant to Radisson Blue Hotel, Guwahati, where after she was intoxicated to drink, he took sexual advantage and the intercourse.
This is in reference to her statement, 164.
Yes.
Yes.
Hotel. Accordingly, a notice under 91 CRPC, Lordship kindly see now, 91 CRPC has been.
Yeah. I thought it is the same, but when he called out the item, I thought it was another item. Yes.
Approval of the superintendent pursuant to the recommendation of the committee. Lord, you will find that flag mark B. In the forwarding itself, in the top, it has been mentioned. Flag mark 3.
What file is this?
They used to maintain their.
Huh?
They used to maintain the records in this sort of file. In the superintendent office.
Is it?
Yes, sir. There's a dispatch, volume 1, volume 2.
This is the commissioner and secretary's.
No, flag mark B. B. Just below the flag mark, Lord, you will see handwritten note. At the top, right hand corner. That is the order for detention.
For committee suggestion, invite tender to game portal. Why this date is also overwritten?
It is already there. I'm holding this brief record for more
We
than a
have the
month.
office note and not.
No, in tender matters, only this particular communication are there. Even I've got the first
When
tender.
it is more that in tender matters, it should be done because transparency is what is important.
No, I have found in other tenders too,
I don't know about
They
that,
used to
but
keep the printouts and all.
how do we know?
And in medical, probably, they are not that acquainted with all this. In fact, I've got the volume 2 and 3 one also. The first tender and the second tender, where it has been.
You see the signature, have you seen?
Well,
Have you seen the signature and
yes,
the date?
yes.
Why the date is like
Yeah, I have asked them, In fact, in the second
it has to inspire confidence, no, Mr.
I
Principal?
understand. That's why I asked them, They said that it is there. And so far as this particular record is concerned, I'm holding this for last more than 1 month. Pursuant to the court order. It is with me. It's not that it has been now manufactured or it has been now.
I'm not saying that, but see the signature. And it simply says as per committee suggestion in tender.
Lord, you will see this, This is the first tender cancellation. Same overriding. But the superintendent, instead of writing float tender, it has been written as some spelling is also wrong.
No, in that case, then there is no proper application of mine. Because apparently it is not the observation of the committee that because of
He accepted it. That is their version. They accepted it. It's no problem.
Sorry?
He accepted it, whatever was the
No, I'm not
recommendation.
saying that. The committee, before opening the financial bid, knew
Well,
that there were two tenderers, right?
Yes, yes, that part probably,
Two tenders. And they said that, however, we had decided we'll open it because this is the third retender.
yes. Third
This
reason.
is what I think, if I
In
recollect,
the my lord, yes, technical bit minor.
that is what was stated.
Yes, yes.
But after opening, then again they said, no, GEM is required.
And for more participants. That's two grounds.
That's what they said. And the competent authority, there is no independent exercise of mind. That's why I use the word postmaster.
That I leave.
He simply said, as per committee, and right.
In fact, my lord, this, what is there in the record. This is the first one, my lord. Just to show, my lord, sometimes, my lord, overriding, my lord, not deliberate.
Where?
That, my lord, one flag mark is there, or to be see that flag mark.
Pink.
Pink. No, the orange one, my lord. Star one. In between, my lord. It says floor tender, retender.
Hmm.
Spelling is perhaps, my lord, wrong. But
Anything else?
this is the second one, same, my lord. It has been mentioned as as per committee suggestion, retender.
Hmm?
The second, my lord, cancellation. And my lord, regarding that, my lord, opening of the bid, my lord. In between.
Second tender plan for the Yes.
Regarding the retender part, it was open. I've got a written instruction to the effect. And my lord, the region.
It was opened.
It was opened by two. But the reason, my lord, that since they have taken a decision to, my lord, cancel it, the result was not uploaded. And my lord, it is for the benefit of the petitioner as well as the other bidder. Moment it is uploaded, their rates will be known to all. That's why, my lord. Or probability, my lord, though it's not there reflected in the minute. But my lord, that is even otherwise a ground.
Committee knows now.
Committee knows, but my lord, it has not been disclosed otherwise to any bidder.
Committee knows there.
Otherwise, my lord, the petitioner would have known it. That
Committee, you see, that is where I am having a difficulty. If the only ground of rejecting them is about participation, why to open their bids and see their rates? Why do that? Committee could have straight away said that only
Yes,
two
fine.
bids have come.
Considering the ground, perhaps, my lord, but it's
And
not
this
that
GEM, what is this GEM? It is another way of calling. In any case, it was an open party, and Mr. Sharma is right. Now you are restricting also. If you mandate GEM, it is only those kind of bidders who are registered perhaps could participate, isn't it?
Yes, my lord.
It is only in
Yes,
case
yes.
of registered.
Gem
What is it called? Registered?
Gem registered, my lord.
GEM registered.
But nowadays, my lord, every bidder they used to get registered. Because
They are
this is
registered.
procedure now. In government, my lord, it's Gem everywhere.
But you see,
Gem portal is a
but
central.
you see, Mr. Gokoi, this is the third time.
My lord.
This is not the first time. And it's not like in the first and second time you had a lot of participants. Isn't it, Mr. Gogoi?
My lord, I understand.
There were not that there were a lot of participants in the
No, in
first and
first
second.
tender, only one bidder was found to
Correct.
so that is the otherwise a genuine ground. Second, my lord, out of four, all four were disqualified. So
That
it
is also
automatically
genuine
cancelled.
ground. There is no difficulty.
Third one, perhaps, source will have to adjudicate.
No, that is where the reason. Otherwise, you know that in policy matters, this court generally
In fact, my lord, here my argument will be
interfere because ultimately we think it's best to be left with the experts.
no. Here my argument will be, my lord. In between, my lord, there was a change of policy. That notification came up.
Change of policy.
Directing all the procuring
but,
entities to go for Gem.
No, but that came one day before the issuance of the tender.
One day
right?
before, yes.
One day before. Now that whether it was communicated, not communicated,
It is there in the portal otherwise.
So all that is there, and the ground which is taken.
Well, I have a
Why after opening financial bid? Why not before that?
considering that, my lord, wider participation part. Otherwise, my lord, it's not, my lord, even after declaring the financial bill result also, my lord. If the rates are not found to be feasible,
Exactly.
we can reject it. It's not that we cannot.
That is not what has been done, Mr. Gogoi. This is what from that day I'm trying to tell you.
Lordship.
This is not what has been done here.
My lord.
I could have understood if we would have done that. That the rates is not,
In fact, my lord, that could have been mentioned in the
that could have been done, but that's not done.
not the
Now you cannot improve that situation.
fine,
I cannot presume that situation.
of course.
Yes, what do you want to say?
My lord, here, my lord, they have stated that, my lord, it was so open, it was never uploaded. And in fact, my lord, whatever
Where is it stated here?
yes, Lordship will see it, my lord, in the 7th line. According to the minutes of the tender financial bid, although was open through online mode, not signed and endorsed by any members of the tender committee. But in view of the finance, that government notification, it was cancelled. That line is otherwise there. In fact, the result. In fact, the results are also there, but it was not uploaded for the benefit of the both the bidders.
Now this notification whereby the GM has been made mandatory, which is that notification?
Yes, Lordship, that Lordship will find in a affidavit.
But that notification has not yet been gazetted, right?
My lord, that I have sought for instruction from the finance. They say that it has been given approval by the highest authority, that is the Honorable Chief Minister. And thereafter it was uploaded. Gazette part, my lord, I am yet to.
No, because as per this,
That 24 rule.
it's required to be gazetted.
Rule 24, sub rule 2, clause 4.
Rule.
Lordship will find that, my lord, in page number 35. 100, my lord, page 100.
Page 100.
Yes, sir. But this is, of course, my lord, it says notify. Roman 4, my lord. The state government in the finance department shall notify the detailed guidelines for such online procurement to them. Although
No, but how to notify? Somewhere it was mentioned, no, official gazette.
Yes,
Where is
they
that?
are in the definition.
2Q. Yes, notification means the notification published in the
Yes,
official
page
gazette.
5, my lord. Yes. No, I understand, my lord. That's why I said, my lord, this is the
So
point, my lord,
then,
taken.
if we go by this, that OM has not come into light,
Well, specifically, my lord,
and
yeah,
yet
am
after
unable-
opening the financial bid, it is
yeah, on that ground, it was cancelled. One of the ground.
how can that be? Both the grounds are not available. First ground about participation, they knew it. With their eyes open, they knew it, how many participated. Despite that, they took a decision
My lord.
in their wisdom that no, this is the third time we read that it has been retendered. We'll go ahead, we'll open the financial bid.
My lord.
And yet after opening the financial bid, we don't know what happened, that a somersault has been taken. And they're like, no, now that there is a GM and we will go for fresh tender. That is not inspiring confidence, Mr. Gokul. And that GM apparently is, you could have published it.
My lord, regarding, my lord, yes, of course, my lord. Another
Because
ground-
legal position, you're not, you are admitting that the notification has to be published in the official
my lord,
gazette.
apparently from the rules, it says
Correct.
notify.
Correct.
I can,
Correct.
in fact, my lord, under this particular provision, Lordship, may kindly have a look at that, my lord, notification one. Does that provision?
Yes.
It is, my lord, running page number 105. Lord,
105.
105 is part of the affidavit of opposition.
Huh?
Running page 105.
This annexure A, isn't it?
Yes.
Ah.
Annexure A.
Yes.
Lordship will see capital A, para 1.
Yes, for procurement.
Government so-and-so is mandatory for all procuring entities for procurement of all goods and services that are available in them as per rule 24(1) to Roman 4. So
This is
yes,
that
that's why I'm
it is
saying under
notified.
that power this has been issued.
Yes, I understand, but power is there. You see, you have the power, but in what manner that will
In
come
due
into
adherence,
effect.
in due adherence, it will have to be.
Correct. That is given. Notification has to be
But that
gazetted.
instruction, of course, I have sought from the finance. In fact, they have inquired in them also. But when in the website, this particular notification is there, not the gazetted one. It will have to be there. Otherwise, there will be again a ground.
Sharma, I think that information is also vital.
Yes.
He says that he has asked from the finance department whether this notification has been gazetted or not.
I tried, Lordship, I talked to the, he is not there. I have said.
Even then, my lord, let me have a
I think
conference.
Mr. Gogoi also in
Yes,
his
yes.
heart knows 90% it is not them, but he doesn't want to
Yes, but
make that
make a
commitment
statement, my
without
lord.
being
It
there.
will have, my lord, ramification in other.
Correct. So you have it. Monday.
Yes, only my lord, I will place the return inspection, my lord. So Monday, my lord, tomorrow is a holy, otherwise it's a fourth Saturday. Probably.
Monday at 2 o'clock
My lord, yes. At 2, Monday.
or
Or
Tuesday.
Tuesday, my lord, at least I will get one.
Tuesday. So Sharma, you will be there. But I'm going to start the process of dictation.
Yes, yes,
Facts.
yes, yes. Facts, lord, yeah. Only one or
With
two
the
petition I will
understanding
place, my lord, otherwise the
because-
counter this.
You don't have anything else, right? That's all in your argument.
Only, my lord, there's so one or two judgments I will place, my lord.
Give it, you complete that part.
Lord.
Tuesday, we can just keep it
Yes,
for
yes.
that,
Yes, ma'am.
because that will have an important bearing also
Yes.
for this court to take a decision. You see, Mr. Gogoi. Mr. Gautam, did you prepare a small synopsis or something?
Will submit it by the next day. I've prepared a judgment compilation. We'll have it.
My lord, one amendment was made, my lord, by way of additional affidavit, where they have annexed various, plus, my lord, NITs under them, under the state portal, my lord. Their argument was that, my lord, despite having this
Different
particular
department.
notification by various departments, they have been still using, my lord, the government portal. My lord, regarding the Assam Medical Service Corporation Limited, who majority of their, my lord, tenders are of this particular corporation, which is a state corporation. They have clarified that, my lord, so far as their items are concerned, that are not available in the JAM portal. As Lordship has stated, my lord, they are to be prior registered. Items are registered, my lord. Those, my lord, tenders, my lord, the items are not available in JAM. The jail home department, I am not representing, my lord, that.
So those specific items are not
Yes,
available.
yes.
That is why it is not
But they have
insisted
protested.
on GM.
But regarding, my lord, the home department, my lord, being a council for the, my lord, health here,
Because the OM also says that are available.
that are available, yes.
So only in respect of items which are available in the
In
portal.
them, they are to be protected.
What is this exactly the process? It's ultimately an electronic mode of
Platform, my lord, it's a
procurement.
platform, my lord, where, my lord, it's a central one.
So here, suppose one person wants to sell his good.
Yes.
That good has to be
He
listed
will register it in the JAM portal.
in the
which
GM.
Giving the all specification.
And
Now, my lord, if any department or any purchaser, they want to have it from them, they can have access to that particular product, what is the quality and their specification already available in them.
And how does the procurement happen? Because one of the method is also auction. Then
One of the method is auction, another is, my lord, open competition. All tenders are open competition.
competition would
As well.
mean the same.
Technical bid, financial bid, two
bids.
bid more, yeah.
Now here, how is that done? First of all, the good is listed. Now this good,
No, they will see, my lord, whether the goods are available. Not only one, maybe.
here the tenderers are going to give the goods.
No, tenderers will give their scope of work. What sort of goods they want. Maybe there are various, my lord, say particular product. They will give their requirement. That these are the minimum requirements that will have to be there in that particular.
Here the tender was for dietary product.
article, yeah.
Now these dietary products are listed in
So
the
that will be a rate contract, my lord. That 36, section 36 speaks about rate contract.
but rate contract is a different.
No, rate contract will be, my lord, say, my lord, here it's not that one-time procurement. For entire 2 years, my
I'll
lord,
tell
they
you
will
one thing, because this GEM and rate contract, they have been clubbed together, but they
or it
both
says or, yes.
correct, but they or means is disjunctive,
Either,
isn't it?
yes.
Either alternate.
My lord.
So rate contract is
No,
different.
my lord, it says 36 says rate contract and JAM e-market. Lordship will see page 27 of the
And it is and not
And
or.
that.
And
Rate
then it is
contract and
conjunct.
government e-market. And he says, my lord, rate, what is
Sorry,
rate
how
contract?
does it read?
Rate contract and government e-market, that is government e-market is there. GEM, government e-market,
So rate contract and GM is one thing.
one thing. So how it is to be, my lord, done, that is it based in section 36. And he says, my lord,
No,
the need,
I did try to understand today morning reading the Mr. Sharma had given this.
yes,
It was
This
quite
is the only
helpful.
document I,
Quite helpful.
yes,
I was trying to go through
it
it.
is a government document.
Yes.
in fact, my lord, from that,
To just understand this whole procurement process,
my lord,
because
from that particular point has been pointed out. that
I'm like Mr.
minimum-
Sharma, even I'm new to this.
No, we all are new, man. These are
Yes.
newly evolved procedures, my lord, for
So
procurement.
by now you must be more acquainted dealing with this, being in the
Yes,
government
few
side.
cases I have appeared.
Yes.
But my lord, to the extent my learned senior has, my lord, placed the rules and all, and his document is the first time, my lord, that it has gone into too deep.
No, one has to
Yes, yes. For,
to understand the whole concept, because what is so special of the gem that it has been made mandatory? This is also to be understood, right? So perhaps it is to make things more transparent. Now there is nothing wrong in
and to
that.
bring it into one umbrella, it's a
That
separate
is
question.
nothing. But first and foremost question that this court perhaps in this writ petition has to decide is whether this has been made effective or not. Because it can only come into effective if a proper reading of the rules are made.
Yes.
Then it is apparent that it has to be prescribed. In the official gazette. So then you have to show that.
My lord.
Suppose now you show it. Suppose you assume that on Tuesday you can give us.
Yes.
And this was done before.
1 day before.
1 day before that gadget notification. Then of course it is applicable. Now, in that situation, why the same committee people on the first day could have taken that decision, but they did not.
Technical stage.
Anything else?
My lord, otherwise, my lord, these are the ground. Then, my lord, I have placed the letter also, my lord, regarding the other part. That, my lord, they have placed in the additional affidavit various e-tenders, my lord, under the government e-procurement portal.
Given this
Two
letter.
written documents, yes.
But have you given these to them?
Yes, yes, I have provided a photo.
Huh?
The last one.
Mr. Sharma, have you received?
Yes, yes. The last one. Financial.
Why don't you put this also by way of a small affidavit? You can file it on Monday itself.
Yes, then it will be more convenient.
I think they will also get it. It will be easy for the court also.
It will be at least on court record.
Yes.
That I will bring it in a way.
Only these two documents.
Only these two documents.
And in case you, by then you get hold of that, Mr. Gokoi, by then if you get hold of that notification, you put it in that affidavit. Yes, Mr. Sharma, you want to say something?
No, Lordship, the second document I
Yes,
have not.
there is one page that I will provide it.
No, I think it's better if he puts it by way of an
Oh,
affidavit.
yes, yes, that's good.
Isn't it?
Oh, okay, then I'll get it.
Because
If
Monday I
only
will
thing, Lordship, for a moment I can see the
Yes,
record, Lord. In front of the,
Yes,
the last one only, the
third one.
third one.
My lord, so far as this, my lord, documents that are annexed in the edition.
Flag B. It's a note on top.
Right.
Mr. Gokoi, another thing.
So this is not uploaded.
No, it's not uploaded. Yes, because my lord, because of
We have
the-
any decision loss, any decision in a online tender, it is to be uploaded. Otherwise, no loss.
That I
There
am
is no
specifically
point keeping it
it
in
has not been
the
uploaded.
Electronic mode.
There is no point of this document not been uploaded.
That is there.
Please direct.
Plus,
They said
till
not
now,
on-
the gadget notification has not been brought on.
And the
has been shown.
26 Roman 3 is direct violating those.
Yes,
Then Losik can look into that document because their rule has said that any document not been uploaded, no. Section 22.
this is where the difficulty, Mr. Goku, a lot of
Yes, yes, there's some loophole.
it's not followed.
If Losik, he will give that affidavit on that day, or he will show the judgment today, Losik, even I can complete my part.
Yes, yes. Surprise, my lord, this
এইডোখন হেৰি কৰি দিয়ক। Clip এটা লগাই দিয়ক। You want this back?
yes, my lord, I'll file my affidavit. Regarding the various documents that have been annexed in the additional affidavit about various other departments, my lord, submission will be that, my lord, if some other department like the jail, my lord, authorities there.
You also give a small
Plot.
note on your
Plot.
reply.
That part, my lord, my submission will be, my lord, they cannot claim negative equality in a case. Somebody has done it, that doesn't mean that has become a rule.
See, for this, in this case, though one may not go that far.
Yes.
You
my lord,
just,
since
you
they-
just
they've
have
got
to-
on record.
Yes, I understand. Suppose to, you just need to show whether these things have been followed.
Yes.
Till now, it appears that nothing has been followed as per the rules.
And what's it, my lord,
The
that-
decision is not
my lord,
taken.
judgment, may I refer to
The
judgment?
decision is apparent, is not
Yes.
exercise of independent application of mind. It is apparent. Secondly, that is not uploaded as per the manner prescribed in the rule.
No, their submission is that, my lord, regarding uploading part. This, my lord, in the meantime, the litigation came. So,
Whatever could be, but the mandate of the law is clear. It 26.2, right?
yes,
26.
26.3.
26.3. All such procurement through GM shall be subject to the prior, no, not that.
No, page 20, Losik, page 20.
Page 20. Sorry, I was in
This
the
rule, Losik is reading the rule.
rules.
It is page 20, Losik.
it says, my lord, it will have to be communicated.
The
to
decision of the procuring entity to cancel the procurement and reasons for such decision shall be immediately communicated to all bidders that participated in the procurement process. And that is also not done. And that is not done in either, even in during first tender.
So in first and the second, it was uploaded.
Uploaded.
Yes, that is cancelled or whatever is.
Third, it was not.
Heard, my lord, they say, my lord, because of this litigation and all, my lord, it ultimately got.
Litigation doesn't mean that you will not do it.
They're
But anyway, even assuming they knew it, so there's no prejudice. But they didn't know exactly what was the decision. Even now, right now also, things are not clear. Isn't it?
yeah. I don't know, my lord, whatever is the record, my lord, I have placed it.
So
And my lord, that is the ground, my lord. They say, my lord, for better, my lord, participation. And my lord, since in the meantime, JAM portal is to be.
That's right, Mr.
Yeah.
Gokul, you've been very fair in your submissions. But the question is
I cannot improve it, my lord.
correct.
So, my lord,
I
my
think now everything depends on that.
gadget department. Otherwise, citation, my lord, there are citations to the effect that, my lord, even if a particular bidder is L1 highest bidder or a lowest bidder, he doesn't have the right until and unless that work order is issued to him.
All that is
No right
okay.
accrues.
You see, all
He
that is
doesn't,
okay.
yes, because, my lord, this is a contract, my lord.
See,
He has offered,
there
he has not accepted it.
There is
now.
no difficulty in all that because we are only examining the decision-making process.
Lordship.
Now, when you see that see these admitted facts. Third time retender.
The third time it can be.
Okay, first two
because
times you had valid reasons. Let's take it. You had the valid reasons.
Now, my lord, whether you can,
But
the
after-
rejection is right or not.
Correct. The
Is it-
manner in which
Right.
it has been done.
My lord, natural justice and equality, my lord, doesn't have any ground in a, my lord, matter of
See,
tender. Of
even
course,
that
Article
Air
40
India
come in.
case, if I'm not wrong, I think Mr. Sharma, it's in the Air India case where Peck Court has stressed that even if a legal point is made out, even in that situation, the court in 226 may not interfere with the.
There, my lord, attendance
It is
judgment.
there are judgment lawsuit.
You
But
see,
there is
they
the
are-
facts of the case
legal
lawsuit to see.
Correct. It all
What is the facts of the case law?
Facts of the case.
After all, the facts of the case.
That's the case.
Settle.
Here, this arbitrariness appears to be a writ large at this moment because you are insisting on a on an OM which appears has
What
not
laws-
prescribed in the official gazette.
What lawsuit under this sky, they can do everything. They-
Now, if it was a already
That part I don't agree, my lord, but
no,
Because-
suppose this was in the official gazette, then of course there was no difficulty. But I don't think it will be there because you see the OM is of 8
Eight.
and this tender is of 9, I think.
no, the decision was taken sometime in February. So there is
No.
a time, my lord, when the financial bill decision was taken. Finally, whatever is impugned, say, my lord, before this.
No,
honorable court.
the official memorandum. I'm talking about the OM.
Yes.
OM is January.
No, it will be effective from the date when it is published.
Correct.
My lord, on say 1/9.
Correct.
On 8/1.
So
8/1.
this 8-1.
Yes.
8-1 is the decision on which the OM was issued.
My lord.
Thereafter, it has to be published.
Now,
There I do
our
not-
things
Correct.
started in
Yes, yes.
2010.
And on 9-1 to that tender was issued.
My lord.
Now, if this was published thereafter, it will not come into.
Otherwise,
there-
my thing is retender.
Regarding
My
the
lord,
policy.
this
Now, this
started
is the policy of the
2310.
government that, my lord,
Uh-huh.
this is the policy of the government that henceforth from 8/1/2024,
Correct.
all will have to be under,
So that means all,
if the products are available in JAM.
all procurement.
Yes.
Now that has to come into effect. The effecting date would be.
No,
from
that
the
will be
date
the
of
my lord, gazette notification.
gazette
I will-
notification.
After-
That's why I'm saying
Yes, yes.
it doesn't appear that perhaps the gadget could have come
My
in
lord, I
one
will
day.
not say anything at this stage, my lord,
But it
without that.
doesn't look.
anything.
I mean, from your experience, you say, would it be done on one
No, it
day?
can be, my lord,
It can
because
be.
why I'm saying is, my lord, that this particular JAM notification was taken into consideration at that time when the financial bid was open. There is not a whisper in when the technical bid was open. That is sometimes in 22nd of February. By that time, it may be published. So that's what I'm saying, I will have to place it.
Mr. Gogoi, then there is a change in the policy. Now-
That I have got a judgment which says when there is a change of policy, in case of tender is there, my lord, then even, my lord, not a single, my lord, reason is to be given. Because there is a change of policy. No justification is required. Specific, my lord, citation I have. Sure. 2007 to SCC.
You've understood the query, na?
I understand, ma'am.
Because according to my perception, once the tender is issued, if thereafter you make something mandatory, that will not come into retrospective effect to the tender which is already been floated because they have already participated. After participation, suppose one of the tender doesn't have the GEM registration.
No, then, my lord, of course, he will have to get registered. That's a different issue, my lord.
Anyway, sure.
My lord. But it says, which, my lord, 2007 to SCC 588.
2007.
Yes, 2007 to SCC 588.
Yes.
Lordship may see para, my lord, 2, para 2, just to place the fact. Here, my lord, it is the Mumbai Metropolitan Region Development Authority was created so and so. They floated a tender, my lord.
Sorry?
This Mumbai Metropolitan Region Development Authority, they floated a tender for construction of a complex.
Yes.
Now, Lordship will see para 4. The tenders were to be considered at 3 stages and thus 3 different covers were to be submitted along with the tenders. The first cover contained compliance with minimum eligibility criteria. The second cover contained financial bid and the third one contained technical and business proposals. The technical bid was opened on 5/7/2003. The financial bid was thereafter opened, which was contained in the second cover.
on 8/5/2023, the appellant was the highest bidder, have offered so and so. Now, Lordship, 7, para 7, the same, briefly I am placing the fact. The authority, however, took a decision to reject all bids on so and so, which was said to have been communicated to the appellant by a fax message on so and so. The reason, Lordship, will find why it has been cancelled. Para 13, madam. The contents of the respondent before the High Court, it was put to challenge before the High Court. B, my lord. 13B, the authorities acted reasonably and fairly and have now reached a decision to set up the convention center on their own without any private participation. So this was the policy. Para 59, I will rely, my lord, to place this particular point.
Contentions of the respondents of the High Court where the decisions to reject all bids is in pursuance of the power which was conferred by the terms of the contract. The authorities went through and yes.
Now, my lord, para 59. Speaks about the region, my lord, whether regions are defined or not. 59 says some reasons may be required to be assigned for rejecting the bid, but in an instant case, in our opinion, no reason was required to be assigned as there has been a change in the policy decision. Then instead of
When did the
tendering,
change come?
by giving to a third party
When did the change come
during the tender process, madam.
in this case?
Yes, sir. Then
And what was the change?
change is that, my lord, that part, my lord, para 13 I have said, that they decided that they, on their own, they will, my lord, construct it instead of giving it to the builder by way of a tender.
By
Para
virtue
13,
of section 12(1)(b).
Not 13B, my lord.
13(b).
Yes.
14(b). 13(b), the authorities acted reasonably.
Yes, yes. They've given the reason in before the honorable court that why they have cancelled it after opening of the financial bid. The authorities acted reasonably.
Sorry, this is not being clear.
No, it is their contention. Also, we will see para 13 first line. The contention of the respondents before the High Court were.
Yes.
So this B, the authorities acted, this is their contention that they acted reasonably and fairly and have now reached a decision to set up the convention center on their own without any private participation. So this was their decision that they will not go for tender now. They will on their own, they will construct it.
That is all right. Suppose you have taken a decision like that, that is different. But here the entire you have made it mandatory for GM. This is like changing the rules after the game has started.
No, it came up on 8/1.
But
tender was floated on 9/1.
9/1.
And my lord, it will be effective from 8/1.
That's all right, provided that is why I think there is no point of proceeding with the arguments today, because this part will
entirely, yes, my lord. And it
depend.
has been made effective.
Correct.
Entire
It
argument.
will only depend on the official gadget. If official gadget is done on 8, then you have
made it effective.
You have made a
Even if,
point.
my lord, it is given a retrospective effect. Then also, my lord, we do somehow, my lord, that jam part is
correct. Otherwise, you cannot change the rules after starting
No,
the game.
here, my lord, no, my lord, Lordship will see, my lord, that
Gogoi,
argument will
no,
not
Mr.
sustain
Gogoi,
here.
you could have done one thing. You could have cancelled the whole tender and said, no, now because of this, and retender. That could have been understood if you would have cancelled the tender.
Yeah.
You didn't do that. You didn't even cancel it at the technical bid stage.
Yeah.
You opened the financial bid and thereafter you have cancelled and said, no, now GM.
No, my lord.
That is not very
So far
inspiring.
the change of game is concerned, that cannot be, my lord, considered in the present facts. It's not that, my lord, we have imposed them in the present tender. We have cancelled it altogether. Change of goalpost will come, my lord. When the game is on, we have given a new
That
clause, my lord,
cancellation.
new condition.
I understand, but you see that same analogy will come. Because of that, now you have you're basically
Change of
cancelling
policy,
it.
change of decision.
Correct, but you're cancelling it after the financial bid. You could have done it the moment the notification was published.
Oh, it has come to our knowledge, my lord. Ultimately, yes, no issue, my lord. It is applicable from the very first.
You only told few minutes back that everything is in the portal. You know it.
Yes, yes. It's
Now
there.
you
That's
said
why-
it has come to your knowledge.
No, it is there in the portal, but gazette part I will definitely place before this one.
No, not gadget part. About the mandatory requirement of the GM, the OM.
Yes. No, it is required, my lord. My lord,
No, no,
Rule
not that.
24 is very clear.
Remember,
that the
a few
finance
minutes
department
back,
has-
I had asked you whether this is known to all. You said it is known
My
because
lord,
it is there in
when
the.
it is gazetted, it is no matter, my lord, ignorance cannot be a ground, my lord. If it is notified for all.
Mr. Gogoi, that goes, the same goes against the department because they knew it, but they didn't cancel it. They could have gone for a retender after the
But-
OM.
But my lord, we have not published the, my lord, financial
When
bid.
is the technical bid open?
It was opened on 20.
No,
My
no.
lord, 12
that
to
document-
12 to 12
Huh?
12 2024
12
to 2024.
24.
And financial bid was on 22.
20, 20.
20.
224. And this OM is 81.
81 and that 90 is of
And
91.
91, isn't it?
Well,
9124.
my lord, yes, that part let me place. Otherwise, my lord,
I think no point in going without knowing that part.
and my lord, the other judgments are, my lord, on the same principle which they have placed, my lord. I will also place another some different judgment, but the principle is same.
Give because then Mr. Sharma, if
I will give the book list and the para. They can counter on that the other rest.
Okay.
That will be for para can it is-
today you have given one judgment, no?
Yes.
Include this also in that
Yes, sir.
list.
Who I have placed, my lord.
This files you will keep with you.
I leave it to your office, my lord. If you retain it, I have no issues because I have nothing to, my lord, record from that particular file. Only these two documents I will place in the affidavit.
I think you retain it. You just put it your- but keep it, huh, on the next date.
Yes, yes. It will be there. Very good. Is it there? Then, my lord, on Tuesday.
Mr. Sharma, Tuesday?
Tuesday. By Monday, I will file the affidavit. At least I will try to do that by morning.
That they give the reply.
So then at one go you can give your
Yes,
reply
that's
because
yeah, otherwise
it is important to know that part of the information about
Even-
the official gazette.
my humble submission, lawsuit.
It will not be
It is
there.
gazetted lawsuit. Even then they cannot lawsuit. You also display from the rule. They cannot sense make it mandatory lawsuit.
So that would depend when it has been gazetted.
So in
Yes.
that case, my lord, mandatory part, my lord, they will have to challenge the notification, thus making us.
Because it will all depend on when it was gazetted.
No, my lord, I will not challenge the notification.
No,
If there
that's
is an
explaining
act
what-
and the rule, notification cannot override the act and the rule.
But, my
So
lord,
I
that's
will
the
not
word-
challenge
So
that.
you mean to say even the GM mandatory requirement, even if it is published,
Hmm.
it goes contrary to the.
Yes, yes, my lord, I satisfy lawsuit one reply. Yes, it is very specific in the rule and the act law. They cannot.
No, but under the rules and act, if I recollect, the option is there.
Option is there, option.
Now
Yes,
then,
lawsuit is very correct. It is one option.
Yeah.
They cannot make it mandatory law.
if
Jam is the only procurement process.
suppose the state government for particular goods which are listed is of the wisdom that for
And
that-
then they cannot give it retrospective. This is started in 23/10/24.
but those were cancelled, no, Mr. Sharma.
Not cancelled, it is retender. All these tender are retender lawsuit. That is why when I started with the reading, the word is retender. It is retender lawsuit.
You have this reply to this part of the argument ready also.
Yes, yes, and
You see,
whether, my lord, retender amounts to fresh tender or it is a continuation of the earlier one. That I will try.
It is a
see if you
retender.
can get an
If any
authority.
authority is there, I will say.
And that is why I have not challenged the earlier tender lawsuit. Why I have done? Because it is a retender. I'll satisfy on that, Lordship. And the
Retender word is yes, but
It's a fresh tender because in my
in some, in other words, would be like a fresh tender.
Preferred mode as per the statute.
because my lord, in the
which is the preferred one, Lordship, it is there in the act. I'll satisfy.
All right.
They cannot make the jam a preferred one, Lordship. They cannot. Under the act, they can.
Same mandatory for.
Mashwar, heard Mr. S. Sharma, learned senior counsel, assisted by Mr. A. Gautam, learned counsel appearing for the petitioner. Also heard Mr. B. Gogoi, learned additional advocate general appearing for the state respondent. In terms of the order dated 27/5/2025, Mr. Gogoi, learned additional advocate general, has placed the relevant reports relating to the decisions of the respondent number 4 in connection with subject retender. Upon perusal of the records, this court, upon perusal of the record, after perusal of the record, it is necessary to a query has been raised as regards the publication of the office memorandum dated 8/1/2024 in the official gazette, to which Mr. B. Gogoi, learned so and so, seeks short accommodation for apprising the court as whether the said OM has been published in the official gazette, and if yes, on when, and also place the same before this court. The then you say list on Tuesday, on such and such date for further hearing. It
2
is
PM.
needless to be clarified that Mr. B. Gogoi is at liberty to file an additional affidavit if need be to bring the aforesaid document on record. So I've given you that liberty, so you bring those two.
Yes.
File. What was those two documents?
One is regarding that, my lord, from the corporation of the health department.
Then let me put
Yes.
these two letters also. Including the letters
Letters dated, my lord, 9/5/2025
9/5/2025
and 25/4/2025
and 24
25/4/2025
25/4/2025
produced today before that.
produced today before this court. In that affidavit.
Interim order.
Interim passed earlier. Interim order, if any, shall continue till the next date of.
For further hearing.
Yes, I have said. Yes.
People.
এইখিনি ভালকে থৈ দিব হা কেছখন। Yes, time frame.
My lord.
Huh?
Within 4 weeks,
4 weeks.
because the proposal was received on 8/5.
Yeah. That proposal was given to me, no? Where?
Yes.
See, Mr. Roy.
I've asked for 2 weeks.
Huh?
I've asked 4 weeks it will be because the proposal was sent.
All right. You see, we have waited for so many years. Now 4 weeks is okay. You can wait.
Yes.
But at least there will be some certainty
Right.
that he will get it. If you would have adjourned it, it would have again ultimately when one litigant comes to the court, to a writ court, he comes to get some
Really.
justice, no? Otherwise, what is the point
Right.
in keeping these matters pending for so long?
Right.
His sufferings are getting more prolonged,
Right.
not getting addressed. Yes, Makta, please take down. heard Mr. N. Bora, B-O-R-A-H, no? Bora, learned counsel appearing for the petitioner. Also heard Mr. S.S. Roy, learned junior counsel, no? Learned state counsel, government counsel. Anybody else?
Number one, revenue.
And who was there? A. Bhattacharjee. A. Bhattacharjee, learned standing counsel, revenue. In the first half, I thought one girl was there.
For P9.
And MS? Barwa, I think.
Borwa.
Barwa
PR. Sorry.
is there. Ms. Barwa, your initial is H. MS H. Barwa, learned standing counsel. Learned counsel appearing on behalf of Mr. P. Nayak for the respondent
Letter.
or respondent GMDA. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking direction, inter alia, for payment of the compensation cost due to damage due to eviction from their land.
Not their land. This was the government land.
Due to eviction from the land in which they were
Possess.
from the land where they were residing
Residing since 2006.
since 2006.
Six. Some 2000, some 2006.
It appears that, which is that first order where Ms. Burwa had, you had pointed out in the morning.
7/3/2020.
7.
One is 7/3/2025.
It appears that on 7/3/2025, MS Barwa, learned counsel appearing on behalf of Mr. P. Nayak, learned standing counsel, Housing and Urban Affairs / GMDA, on instruction, submitted that the credentials of the petitioner numbers 2 to 5 have been verified with regard to their APDCL consumer numbers and GMC holding numbers, and after verification and that the verification process is complete, the matter shall be now placed before the district commissioner for consideration and disbursement of compensation amount thereof to the aforesaid petitioners. Now, apt to reproduce the aforesaid order dated 7/3/2025 for ready reference. Quote unquote. You please quote it, huh? Today, when the matter has been called, MS Barwa, you gave this, na? Placed a letter dated 15/5/2025, issued by the Secretary to the Government of Assam, Department of Housing and Urban Affairs, whereby, in reference to the status of verification and compensation in relation to the petitioner's land, to the subject petitioner's land, has in, one. A letter dated 13/5/2025 issued by the Secretary Guwahati GMDA was enclosed along with its annexures. Stop. The aforesaid communication is kept on record and marked as X. Upon perusing the aforesaid, upon perusing the letter dated 13/5/2025, it appears that the names of the verified individuals have already been forwarded to the District Commissioner, Kamrup Metropolitan, for further processing and inclusion in the official list for compensation. It further appears that the disbursement of compensation will follow the standard administrative procedure, and the time required for release of the compensation will depend on the required procedural formalities by the District Commissioner. Apt to reproduce the letter dated 13/5/2025 for ready reference. It's put it in what are the names of these petitioners? Rambaisar Shah. His petitioner number?
My lord, number 2, Dilip Kumar Chaudhary, number 3, Manoranjan Kumar Singh, and 4, Manju Devi,
All right.
and 5, Ram Bisar Shah.
Further, the letter dated 8/5/2025 is also reproduced here under for ready reference, quote unquote. It appears that the names of the petitioner has been is appearing in the aforesaid list of person whose case has been verified and considered for further processing and release of the compensation. So, that being so, this court had asked this court, that being so, this court requested Mr. S.S. Roy, learned government counsel, to obtain instruction from the district commissioner, from the office of the district commissioner, Kamrup M, within bracket respondent number 2, as to how much time it will take to complete the required procedural formality. Stop. Mr. So-and-so, upon instruction, submits that the required procedural formalities from the office of the district commissioner shall be completed within 4 weeks from today. In view of the aforesaid endorsement made by Mr. S.S. Roy, learned government counsel, this court deems appropriate in the interest of justice to dispose of this writ petition by directing the respondent number 2 to complete the required procedural formalities in accordance with law within a period of 4 weeks from the date of receipt of certified copy of the order, and thereafter who is going to make the payment? GMDA.
Respondent number 2, Deputy Commissioner.
He only will make.
He will.
And then you say through sorry, Matwai, what did you write? Dispose of No, please can you read that sentence again? To complete the required procedural formalities and no, you say it like to delete that part. Dispose of with the direction to the respondent number 2 to release the compensation to the petitioner numbers 2 to 5 in accordance with law within a period of 1 month,
4
weeks from the date of receipt of the certified copy of the order, ordered accordingly. Let a certified copy of this so and so be furnished to Mr. S.S. Roy, Leonard Government Counsel, for forwarding the same to respondent number 2 for doing the needful. Disposed of.
pair is there, my lord. Another pair is the pair number 3, page 21.
What prayer?
Pair, my lord, the respondent authorities to provide the rehabilitation granted if they consider.
It is needless to be clarified that as regards the prayer for rehabilitation of the petitioners is concerned, the respondents are at liberty to consider the same.
Much
All right.
always.
We got you need more time.
In this regard, my lord, I have one submission, my lord. In this regard, an affidavit has been filed, my lord.
Sorry?
An affidavit has been filed by the respondent number 3, because of taken up the investigations, crime branch, my lord. In that affidavit, it is stated that 20 lakh rupees has been deposited in my account, which is suspected to be the amount which are involved in the FIR, which was lost, my lord. And thereafter, it is so my prayer is that, my lord, I am ready to keep those amount, 20 lakhs amount in the bank account, but it is a current account and my business was going on through this account. My business was totally, my lord, ruined, my lord, because of this hazard. So I am ready to give any bond to keep those amount, 20 lakhs rupees amount in my account pending, and my account will be allowed to, my lord, run for my business purpose, my lord.
Let us first get this instruction because some inquiry is going on.
It's 2024 case, my lord. And
By when can you have this instruction, complete instruction?
let me 2 weeks. Otherwise, not
As prayed for by Mr. S.S. Roy, Leonard Government Counsel, list this matter after give a fixed date on such and such date to complete his instruction as called for earlier by this court. You complete it.
This is the on that document because my he has said lordship that he requires some more time for because the investigation was not yet complete.
Some more time for what?
For investigation for defreezing lordship because the accounts are 21 numbers of accounts are there. So they are verifying those accounts.
my account, only one account, my lord.
Then why don't you put it by way of an affidavit? You let him because he wants it to be defreezed, right? You are saying you need more time.
Because the procedure is not followed when freeze my
that's why
account, my lord. Because 102
then you do that. Mr. S.S. Roy, Leonard so-and-so has submitted that he has received the instructions as called for and seeks a short accommodation to place the same by way of an affidavit. File it next week.
I will file up-to-date instruction because this was
All right. You file it with your up-to-date list on such and such date after a week here on such and such date on which date by which date the state respondent shall file the necessary affidavit bringing the aforesaid document or aforesaid instruction on record as well as the up-to-date information as up-to-date status of the case. 11 June.
Obliged.
One. Delay. None appears for the petitioner on call list after 1 week on a date to be fixed by the registry. First time.
Here, my lord, the connected criminal revision petition has wrongly been listed. Well, it was another the connected criminal revision petition, my lord.
Is wrong.
Filing number. Yes, it should have been, my lord, 3479 filing number.
Filing number should have been 3479.
79. Another. My lord,
Okay. But in the IA, I can issue the notice. You are appearing.
Okay.
What about R2? Notice has to go private.
Not
Issue notice, condonation application, issue notice. Mr. Your accept, Mr.
DP Goswami.
DP Goswami, Learned Government Council, accept
APL APP. Additional PP. Additional PP.
additional.
Public
Sorry.
prosecutor.
Learned APP accepts notice on behalf of R1. As regards R2, notice by registered post AD within a period of 3 days from today. Relist after 2 weeks on a date to be fixed by the registry. It is further being pointed out that the connected criminal revision petition reflected in the cause list is inadvertently a different one, and the correct criminal revision petition ought to be with
3479.
filing number 3479/2025. Let registry verify and do the and list this IA along with the correct revision petition, criminal revision.
Obliged.
44 days. First time,
Only
private respondent is there. Private respondent is there.
the private respondent is there, man.
Notice. Condonation notice 3 weeks. Registered HD 3 days.
Man. 45. Same, man.
Have also same.
Same.
One respondent.
Man.
Okay, same. Condonation notice, steps 3 days and 3 weeks. Yes.
Right.
190 days.
Condonation.
First time.
Yes.
Private respondent there.
Yes. Second. Notice maybe.
This like what's that? It will be same, but here again the DP Goswami for R1, for R2 registered post 80. Okay? Got it now?
Much up.
3 weeks.
Please, your lordship, this I is for allowing us to make paper publication, my lord.
Paper publication.
Yes. In Dainik Janambhumi and Assam Tribune, my lord.
Why paper publication?
My lord.
Why paper publication?
My lord, we have taken several times steps upon the respondent, but
Masha, you want to be changed? Change her. Call Bhargav.
we have taken earlier steps on both and
Yes. Where have you mentioned the ground?
my lord, yes. Para 1. Para 2, sorry, my lord.
Yes.
We have given 2 address. We have taken steps in Guwahati, Bamuni Maidan and in Jorhat also, my lord. Nobody turned up. Therefore, we
Twice you tried.
Yes. A sole respondent.
Will take your ticket or what? You what? Huh? Up. 1 second, huh?
No.
Mr. Bora, which matter you're waiting for? 39. I think I'm just about to reach. Payment due late. 30 I would, yeah. He's already overburdened with a lot of dictation. That is why we wanted a change. Otherwise, it becomes very difficult in editing and signing. For disposal, huh? Item 37. Heard, Mr.
S.K. Chakraborty.
S.K. Chakraborty, learned counsel for the petition applicant.
Applicant.
By way of this interlocutory application, the applicant is seeking substituted mode of service upon the respondent stroke opposite party in RSA number 18 of 2021. It appears that despite taking steps upon the sole respondent on 2 occasions, both by registered post as well as by usual process, the appellant failed in their attempt to serve the respondent, to serve notice to the sole respondent. Apt to refer to paragraph 2 of the application, which is reproduced hereunder, already referred. Reading of the aforesaid paragraph, it appears, it is clear that since on 2 occasions the appellant could not effectuate the service upon the sole respondent upon his prayer, he was allowed time to inquire about the proper address of the sole respondent and to take steps. However, despite his best attempt to obtain the proper address of the sole respondent, he couldn't obtain the same. Situated thus, he has filed this present application seeking substituted mode of service by way of advertisement in newspaper, one in English and another in vernacular.
In Assam Tribune and Dainik Janam.
Oh, you have already filed one,
Twice.
dear.
Twice, my lord. First, my lord, because of the cost of the publication, my lord, due to the financial constraint, my lord, they could not publish in the first time. The second time, my lord, actually this notice was collected by one of his friend. Then, my lord, he could not hand over to the applicants because, my lord, because of the medical issues. He had to go to Delhi and it remained with his friend. Like, this is the third application.
Despite 2 times this court has allowed you, you couldn't do it. Can't go on.
65 to 70,000 cost was there.
Can't be helped. You have to do it. You have to do it. But that order is already there for doing it. Why do you want another order?
Because, my lord, that was disposed of. IA was disposed of. I could not take steps in time. That to say, my lord, a fresh application has been filed.
Where is that order?
My lord, I have annexed only one order, my lord.
Why have you not annexed the other order?
24
In fact, when you were making the submission also, you didn't refer to this part. That is why this court was immediately allowing it.
I have mentioned in the petition, my lord.
Mentioning in the petition and making a submission are two different things.
Second application, paragraph 3, I have mentioned, my lord.
Second time, what happened? Where have you
Second time,
mentioned?
it was collected by one of his friend, my lord.
Where have you said that?
Paragraph 3, my lord. Collected by one of his friends, Sri Abdul Rahman. Paragraph 3, my lord. Who is also from Jorhat.
It further appears that situated thus, he filed the not this present affair. Situated thus, he filed an application being IC number 2009 for 2023 for allowing his application. It appears that since he could not take steps with it during the time period of the earlier or time period of the it further appears that this court accordingly permitted taking substituted service. But however, as no steps were taken, this court did not permit extension on the basis of the earlier order. However, liberty was given to the applicant to file an application for which the instant application has been filed. For which the second, for which another application has been filed, being IA Civil 1114 of 2020. It appears that in the aforesaid I interlocutory application, this court allowed the substituted mode of publication within by directing publication of the notice in 2 daily newspapers, of which one should be in Assam Tribune and the other in Assamese News Daily, joining Janambhumi, before, on or before 1/7/2024. However, second time also, the applicant, for reasons mentioned in the application, could not take the steps for publishing the notice in the newspaper as directed within the time frame for which the third application has to be filed. Paragraph 3 of the aforesaid paragraph 3 of the application reads as under. Reading of the aforesaid averment, it appears that due to qualified reasons, the applicant could not take these steps as directed earlier. Considering the interest of justice, this court, by way of a last chance, is allowing this instant application by directing the applicant is allowing full stop. Accordingly, the applicant shall publish the notice in two daily newspapers, of which one should be in Assam Tribune within quotes, and the other in Assamese News Daily within quotes, the Doinik Janambhumi. The said notices has to be first vetted to the registry of this court before publishing the same on or before when? You tell a date now.
Within the month of June, my lord.
On or before 2
30th,
months? Before 2 months.
June, within June.
Give a date.
30th of June, madam.
On or before 30th
30.
June. Are you sure?
Yes, yes.
June or July?
June. And appearance date may be given in the month of July,
No,
madam.
no, I'm not giving.
Yes, June.
June 30th June. I accordingly extends this program. I've made it clear. This is
My lord,
the
yes,
last
yes.
chance.
My lord, a date of appearance may be given, my lord. Otherwise, the registry do not accept. Appearance of
where? In the RSA?
No, my lord, in the appearance of the opposite party.
In view of this order, the regular second appeal, the accompanying regular second appeal is directed to be posted on.
No, my lord, appearance of the opposite party.
Appearance where?
In the RSA.
So that's what I'm giving.
Yes.
Why are you saying no? Which date should be given now?
Any date, any date. July, August, any date, madam.
July at a date. And the accompanying RSA be posted on such and such date for appearance of the
Opposite party. Deep level.
Madam, in this case, there is a 10 days delay, madam, in preparing this second appeal, madam.
How many days?
10 days, madam.
10 days.
Notice may go, madam.
Private party is there.
No, private was there. Notice may go, madam.
All right. Heard Mr. I. Chaudhary, learned counsel for the applicant. If you notice query by condemnation, notice registered post AD within 3 days, list after 3 weeks. On a date
Right.
fixed by the registry. Yes, this matters. There was some wrong information given on that day. I think some misunderstanding because the two, let us go one by one.
Yes.
Itu poprak pulila pani. First. Now in this Kanduni IA, let's have IA 3924 first.
Yes, Lord. Yes.
You have IA 3924?
Yes, Lord.
IA 3924 is for condonation in respect of the abatement as regards AP number 1B.
1B, yes. In the 1B, yes.
Right.
Yes.
Now, this.
No?
Correct, Lordship.
Correct?
Yes.
Now, this matter is still pending
Yes.
because it says list after 4 weeks. Now, here, in this, there is a abatement, right?
Yes.
Substitution.
Substitution.
Now, that has been disposed of.
That's been allowed.
Correct. Now, kindly come to the order sheet, to the last order, 24/3/2026. The substitution is allowed.
Yeah.
But if you come to the pleadings, kindly see para 4, page 6.
Of 3924, Lordship.
Yes. Yes, 3925. A separate application praying for setting aside abatement has also been filed. But where is this?
Yes.
This is not here.
Lordship, I'm telling.
Registry couldn't find it.
Yeah, no, Lordship, in that regard, Lordship, in fact, Lordship, that part I have checked in the website of web. Lordship, I rightly thought that the Lordship will point out this one. As per my knowledge, all the 6 application has been filed, but while listing in the cause list, only 5 IAS was been listed.
But then let registry.
No, Lordship, the filing number is IA Civil 13929.
One sec. Filing number is
IA Civil
IA
Civil
Civil
13929
13929
13929.
929. Yes.
13929.
13929.
Yes, Lord.
Yes.
/2024. Lordship, that is the filing number, but against the file number, we have not got the case number. So perhaps Lordship, it's in the file, but it's not been listed.
Then he condonation to Utikita illegally. It appears that in I Civil 3925 of 2024, this court by order dated 24/3/2025 has disposed of the substitution, has allowed the substitution application. It further appears that a separate application praying for setting aside abatement is stated to have been filed.
Yes.
However, has been filed by filing number 1 capital A C 13929/2024. However, the same is not available on record. Let registry verify and place the same on record.
There's no point basically we file condemnation delay for setting aside and we don't file as.
See, delay condonation without doing it, substitution could not have been done.
In fact, Lordship, before
Anyway,
substitution,
now let's see, registry put this and then this court will see.
It has to go step by step. Possibly.
Yes. Come for order.
Yeah, please, dear Lordship, we have already taken steps and nobody has appeared. on behalf of
And
the
records
respondent.
also received, so we have to control the records also.
Huh?
Records also received. Lordship.
Case records have come.
Yes, sir.
R2. This is what case?
Lordship, this is, we have challenged the order dated 19/9/2023 for quashing the proceedings of CR case number 154 of 2019.
Offense is under
Section 534 of IPC.
and the service in R2 is complete. R2 service is complete.
So
notice could not be issued to R2 due to non-receipt of step. You're not taking steps.
We have taken steps.
No, that is what the office
We will
note
take
says.
fresh steps.
You see, Miss Counsel, I really do not understand why you counsels cannot go through the office note and see why the matters have been placed for orders. The first thing you need to tell the court is that you want to take fresh steps. Had you seen it, you would have known why the matter has been placed before order. Yes, how much time?
2 weeks.
Huh?
2 weeks.
Your name?
A Lala.
MSA
Lala.
Lala Learned Counsel appearing for the petitioner submits that steps as directed earlier in respect of respondent number 2 shall be taken within
2 weeks.
2 weeks. Huh?
2 weeks, sir.
2 weeks? Why 2 weeks?
1 week.
Why 1 week? 5 days. Within 5 days from today. In view of the aforesaid assurance, relist after 2 weeks on a date to be fixed by the registry. Take it. Otherwise, I'll dismiss it.
Hello.
May I plead your lordship? Lordship, this miscase has been filed for restoration of writ petition number 6/1/2020, 2015, lordship.
Restoration.
Yes, your lordship. This writ petition was listed before this honorable court on 23/11/2023, lordship. On that day, lordship, the counsel for the petitioner failed to appear before this honorable court when the matter was called for. And on that day, lordship, the honorable court fixed the matter on 28/11/2023 and made it clear that in case of further non-representation by the petitioner, this court may pass appropriate order in accordance with law. Thereafter, lordship, though the matter has been fixed on 28/11/2023, this matter has been subsequently listed only on 2/4/2024, lordship. On that day,
Sir, this is a condonation application.
no, lordship, restoration application.
Whom did this have? This is MCA 75.
Yes, your lordship.
Why it's a delay 79 days?
Lordship, initially that was they have initially, lordship, the objection was raised by the registry filing section, but subsequently that
there's something wrong. They've given a wrong file.
Please, your lordship. Lordship, we are the respondent in this RSA matter, and we have filed one IA for early hearing, your lordship.
This IA 1414 is the early hearing?
Yes, your lordship. 1414/25.
Yes, any objection?
No, lord.
Your name?
FN Jaman.
Heard MS FN Jaman, Learned Counsel for the applicant. Also heard one by one. Tell your name.
M. Ahmed on behalf of
M?
S. Roy. M. Ahmed.
M. Ahmed.
Yes, Lordship.
Learned Counsel appearing on behalf of
S. Roy.
S. Roy. Learned Counsel appearing for respondent number?
Lordship, they are the appellant, your lordship. I am the respondent.
In the IA.
In the IA, they are the
correct.
Yes.
Respondent stroke appellant. Mr.
Here I will pray for. In the respondent 1 to 5, our name may not be shown in the process that we have written. That has been taken.
No, but I am right now passing an order in the IA. Are you appearing or not in the IA?
I am not appearing for that.
Yes, Mr. Bhattacharya, you are appearing for
Respondent 678.
KK Bhattacharya for the state response. You are appearing as a government counsel.
Yes.
Government counsel. By way of this application, the applicant is seeking early hearing of the accompanying RSA, RSA number 69 of 2021. Peruse the grounds, and upon being satisfied, the IA stands allowed. The list the accompanying RSA for hearing in the month of June on any date.
Lordship may fix a date.
Or any date to be fixed by the registry.
Our name may not be shown in the process.
In the RSA.
Respondent 1 to 5.
That on that RSA you make it next. I dispose of.
Lordship, initially condemnation petition was also filed, lordship, for condemnation of 79 days, lordship.
Yes.
But subsequently, lordship, registry has accepted that, lordship, for restoration of application, lordship, writ petition, lordship, condemnation is not necessary, lordship. Therefore, this miscase has been registered.
Where is that note? And what about the notice to the respondent?
Lordship not yet restored, Lordship, notice to the respondent.
Alright, then issue notice,
Yes, Lordship.
steps by registered post 3 days, list after 3 weeks. শুধু ভালকে কৰি দিবা দেখা।
Highly obliged. Yes, your Lord. Thank you. Highly obliged.
What is this criminal petition, Mr. Bora?
My lord, this is a application for the quashing of the FIR. The page 25 is the FIR, my lord. It prima facie appears, my lord, no cognizable case has been made out
Yes.
in the FIR itself. If we go by the plain reading of the FIR, my lord, it is only on assumption.
Yes, Mr. Goswami?
It was gone through by my lordship, APP transit law court. He was in court in another court, Lordship.
Oh, he is appearing in there.
Lordship.
Monday, Tuesday?
Right.
He's in another court or he's coming?
No, another court. Lordship. So Monday, Lordship.
Huh?
Monday.
Mr. Bora was waiting for a long time.
More, I am also waiting for his coming, Lordship, but he is not coming.
Yes,
Wednesday.
Wednesday. Heard Mr. A.M. Bora, Learned Senior Counsel, assisted by Mr. D. Vaidya, Learned Counsel appearing for the petitioner. It is submitted that Mr. P.
Locker.
PH Locker,
PH Locker.
Learned APP, who is handling the who is appearing for the respondent state in this matter is on legs before another court, and accordingly a short accommodation has been sought. List again on Wednesday such and such date. Relist.
Interim may continue.
Interim, if any, shall continue till the next date of
Pleasure.